All right, I think you're ready.
Thank you, Dawn. Good morning, everyone, and welcome to the Labor and Public Employees Committee's first public hearing for this session. We welcome you, and we are excited to hear from our speakers today. And I won't belabor the issue, so we can go ahead and get started. What I will do is open the floor for my co-chair and our ranking members to have some opening remarks, starting with Senator Kushner. You have the floor, madam.
Thank you, Madam Chair. And I just want to say to all the members of the public that are watching and that will be testifying today, we look forward to hearing your testimony. As always, the Labor and Public Employees Committee has an ambitious agenda. We seek to really respond to families in Connecticut, and that's our responsibility. And I look forward to hearing from all of you today. Thank you, Madam Chair.
Thank you, Senator Kushner. Our ranking member in the Senate, Senator Sampson, you have the floor, sir.
Good morning, Madam Chairman. Delighted to join you and our colleagues today on this first public hearing for the Labor Committee. I'm sure it's going to be a lively conversation. I do want to mention a couple things. First, I know that some of our members are in multiple committees today and have multiple hearings going on, including myself. So you may see us bouncing in and out of here. Please do not take that as if we are not interested in the testimony. We're just spread pretty thin sometimes, especially at the beginning of the session. And I'm hopeful that maybe the next time we have a public hearing, maybe it's in person or it's a hybrid meeting. I think we're getting close to that. And with any luck, we can get there. Thank you very much, Madam Chairman.
Thank you, Senator Sampson. Representative Aurora, ranking member from the House, you have the floor, sir.
Oh, thank you, Madam Chair. Thank you to all my colleagues, and welcome to all members of the public for being here, for those who are testifying and those who are listening in. The public hearing process is one of the most important process in which we gather information prior to going to committee. I want to express my deep appreciation for the 1.7 million of our members in our workforce in our state who worked through the pandemic for the last 2 years and have really outperformed by any measure in the nation the amount of output and the grit with which they have carried on during these very tough times. Just as Senator Sampson mentioned before, we hope things will get to normal like before, and we'll see you in person in public hearings in the near future. The current situation for our hardworking Connecticut workers is indeed a little tough one, with inflation on one side and job growth and income growth both stagnating. So we stand here to work on, as a committee, focused on those issues. And I think it would be the right thing is to prioritize ideas which would lead to income growth, to job growth, and for better circumstances and opportunities for our workforce. I want to make two other small points. One is I do want to express a little bit of disapproval about the fact that how the bills from opposition or from the minority have been considered in this process. There are a number of bills which our members brought about, and they were never given a public hearing. And I understand the process, and I understand why it was done and how it was done. But I think it is I would be remiss in not mentioning that some of those ideas were very important ideas, and possibly are not going to see the public input. And I want to end by saying that there's a balance we need to strike between the opportunity aspect of what we do, increasing the overall pie, because increasing the overall job growth, the total number of jobs, the total amount of income for our workers, and in redistributing by saying certain businesses are not giving their fair share. I think the balance our focus has to be always increasing the pie, and on assuming that most of our businesses are really good job creators who are doing the right thing always, and to stay away in this hearing and in others for assuming, which happens quite often, that businesses and business creators are, for some reason, the folks who are trying to take advantage. It may be true for a minority, a few bad apples here and there, but by and large, I believe we are blessed. We as a state are blessed with a very entrepreneurial business creator in the business community, which is creating 1.5 million jobs. Of the 1.7 million jobs, 1.5 million are created by our private businesses. And once again, Madam Chair, I do know there is that you hold the time clock, but I do hope that in a public hearing, our opinion and the opposition and the minority will be given some due respect as well as time. Thank you, Madam Chair, and back to you.
Thank you, Representative Aurora. And I'm just going to be completely transparent and honest with you at this moment as we start out. This is a public hearing. We are here at their service to hear what they have to say and to garner, their support or opposition to what we are presenting on this agenda today. So I would like for all of us to be mindful of that. This is a public hearing, and our priority is to hear from the public what they feel about what is on this agenda today. And I will concur with Senator Sampson. Many of us are jumping back and forth, myself included. So please don't take that as a disinterest in what is being presented today, but understand that we are multitasking, and Zoom makes it really, it makes it easy to do that, a lot easier than I think it should be. And hopefully we will get to the point where we are having these hearings in person, because I would more appreciate that as well. There's something about being present in person. So I do agree with that as well. And with that being said, let's go ahead and get started. I believe we've taken up enough of the public's time, and we will get started with our first speaker, Senator Fazio. You have the floor, sir.
Thank you, Madam Chair. I wanted to join you today to speak in opposition of extending HB 5246 and make other general points. Most of us agree that a full-time job is the ticket to the middle class, and that creating as many jobs as possible should be a top priority. Unfortunately, our state has failed on that front. Currently, Connecticut has the 8th highest unemployment rate and has recovered jobs at a slow rate since the height of the pandemic. Over a longer period, it's an even greater crisis. Today, Connecticut has fewer jobs than it did at the end of 1997. So low-income families are hurting from our failure to create jobs and opportunity. And the middle class is seeing shortages, high cost of living, and high taxes from the weak economy. Of course, there's no single cause of the jobs crisis, but there are hundreds of policies that are hurting workers and small businesses from the state government have destroyed jobs, reduced wages, and increased prices. Cato Institute, for instance, ranked Connecticut's regulatory climate the most burdensome of any state in the country, and Pacific Institute ranked it the 5th most burdensome. Yet despite this, we in the state capitol continue to add insult to injury, piling one more regulation on small businesses and workers after another, and destroying demand for labor. OLR published a study saying that the legislature has imposed 28 new workplace mandates since 2016. It's a great testament to our workers and entrepreneurs that they continue to keep their heads above water, but the web of red tape is destroying jobs by reducing demand for labor, reducing productivity, and distracting job creators from delivering affordable products to consumers. The bill in question places new liability on small businesses at a time when they're getting crushed by inflation and shortages. There are over 1.5 million workers in the state, yet if a Stanford restaurant had to lay off 5 workers due to the pandemic, they can only offer those jobs to 5 people in the entire state of 1.5 million workers before anyone else. We shouldn't be penalizing job creation and job creators at a time like this. Not to mention, people with less job experience and longer term unemployment are more likely to be the people most in need. By prioritizing people with more job experience over those with less, this policy poses an equity problem too. Finally, even if a lawmaker likes this mandate, we cannot just keep piling new mandates on small businesses without removing others. We should consider eliminating one old, outdated mandate for every new one that we create. So in conclusion, I think we need to stop growing our bureaucracy in Connecticut and start growing our economy. Thank you for your time.
Thank you, Senator Fazio. Go to my participant list so I can see whose hand went up first. And it appears to be Senator Sampson. You have the floor, sir.
Thank you, Madam Chairman. And I just want to thank my colleague, Senator Fazio, for being here today. I appreciate your comments very much. This law was passed in the last legislative session, and I really strongly opposed it based on it and its, the concept, in fact, and I believe it should be up to employers to make their determination of who the best choices are for employees. I'm just curious, Senator Fazio, whether or not you've read through like the detail of this bill more than just the concept, because I think you might be surprised to find some things that are in here, like the notion that the employer is not just the employer, but in fact could be someone who purchased a business from someone else and would have to recall the employees of the previous business. And the notion that an employee who's qualified is not even a person who's qualified, but someone who could be trained. I'm just curious if you could speak to those things and how you feel about those as parts of this bill.
Yeah, I think you make a good point, and it's imposing a burden on businesses that they've not traditionally had to deal with, and that creates a disincentive not only to create new jobs, because you have this new liability if you do, but it also dissuades other people from coming in and investing in Connecticut, from buying existing businesses, et cetera. So it reduces the value of the small businesses that people own as is. So it's a good point, Senator Sampson.
Right. In your experience, do you believe that there are businesses that are not choosing to come to Connecticut or to your district because of the regulatory environment?
Yeah, and when I talk to small businesses around my district, it's one of the top things that they mention, that the regulatory climate is unbearable in this state and that they're at risk of shutting down, and others have shut down already. And of course, the smaller businesses are important job creators, and they create low income and middle income jobs for people who are most in need. So it's very concerning to me.
Yeah, I appreciate you being here today and bringing some of this information forward, because unfortunately we don't have this conversation often enough, I think, at the state capitol. Let me ask you another question. These days, there's a lot of federal money floating around. There's also a lot of programs and unemployment compensation and so forth. And these things have a place, of course. But do you see an excessive amount of available funds actually being a factor in preventing the accessibility of competent employees and a workforce for our employers in the state?
Yes, and a lot of left of center economists have made that exact point. I think during most of the pandemic, the 40% of unemployed workers received more in state benefits than they did in wages. So, left of center economists who've worked in the Obama administration, like Larry Summers and others, Jason Furman, have said this exact thing, that the high level of benefits have destroyed jobs and reduced economic growth. And because of that, it makes it a law like this even more painful for small businesses, because the people then that they have to seek out are disinclined from joining the labor force in the first place. So again, as I said at the beginning, a full-time job is the best ticket to the middle class. And so we should try to be creating as many jobs as possible.
Excellent. Thank you very much, Senator. I appreciate your comments very much today. I think we're on the same page that we've got to grow our economy and in that way afford jobs and opportunity, instead of simply trying to put Band-Aids on all over the place to try and patch up what we're losing, because we've driven away a lot of producers in our society and the jobs and opportunities that go with them. But thank you very much for being here.
Thank you, Senator.
Next up, we have Representative Aurora.
Thank you, Madam Chair. And thank you, Senator Fazio. I believe this is the first time you're testifying to our Labor Committee. So thank you and welcome. It's really great to have you testify and to present the view from your district and our district and our constituents. Quick question, in your discussions and in your own judgment, would you really agree, or would you think that this bill in aggregate would lead to job losses in job, and to lower net aggregate employment in the state?
Yes, I think it would reduce total employment in the state because it's creating a new liability on small businesses with as few as 15 workers. And it's distracting them from their most important responsibility, which is creating products and creating jobs in the state. And it imposes a new burden on them. So I think it's clear, the biggest businesses in the state can deal with a lot of these regulations, but the small and medium-sized businesses I'm worried about most of all.
What I'm hearing you say is that not only will it lead to job losses, but it would lead to job losses in the small business sector, which is kind of the backbone of our Connecticut economy. Would you is that what I'm hearing?
Yes, sir.
And I also, in your prepared comments, you said that there is also an equity element that this might lead to the younger worker or the more someone who has been long-term employed, or somebody who basically may really be the aspirant. And I'm not even going into the aspect of equity in terms of which town or which specific race or gender. But what I would look to hear more is how you think that this is going to really impact that equity dynamic if such a bill were to be passed.
Yeah, my point is that people with the least job experience, people who have been unemployed for a couple of years, or people who are young and haven't had a job ever before, are going to be the ones who are put behind the people who have recently had work experience. Small businesses are often creating jobs for people who haven't had a job in a long time or have never had a job. And this puts them at the back of the line. So that's where I think it could be unfair and especially burdensome on the lowest skill, lowest wage workers.
So it could be harmful to the lowest wage workers. That's what we hear. And finally, the last question I would ask you is that does this pose risk to small businesses in terms of logistics, in terms of getting their job done or providing their services? Because as it is, it's very hard to get the right people. And if you're constrained more, you basically end up with, and there's inflation in goods as well. Your fuel is expensive, your meats are expensive, your everything is double or much higher than it used to be. So does it pose, especially at that, this is the worst time to think about something like this, because of it may put people out of business, the smaller businesses who are hanging on to their business with a thin line, with a tenuous kind of support. Would you kind of do you have any thoughts or any input into or insights into that?
Yes, absolutely. Again, the small businesses in our district, representative, they're getting crushed. They're having difficulty finding labor. They're having difficulty finding goods. Their margins are being compressed. There aren't too many people moving into the state over many years. So creating more mandates and more burdens on those job creators and small businesses who don't have the resources of a big business, I just don't think it's fair, and it's certainly not good for them. It's not good for the communities that are served by those small and medium-sized businesses.
Well, thank you, Senator Fazio. I think your inputs and insights are really appreciated. I'm so thankful that you're bringing your insights and providing your testimony here. I truly appreciate that. And thank you, Senator Fazio, and thank you, Madam Chair, for the time.
Thank you.
Thank you, Representative Aurora. I am looking. I don't think I see any other hands. And I actually don't have any questions. The only thing that I will respond to is just to say, you spoke about full-time jobs and that's what's needed. And, I'm talking to workers in my district. I'm talking to businesses, small and large. And the problem isn't, having a full-time job. It's having full-time pay. And a lot of the workers that I'm speaking to are like, I'm having to work 2 and 3 jobs, 4 jobs to make ends meet. So when we talk about recall rights, the employers down here seem to agree that they want to bring back the people with the experience. And it doesn't negate the fact that they have an opportunity to hire the individuals that you're talking about. But when you've been down and out, like a lot of businesses have been during this pandemic, and they're trying to get back on their feet, they're looking for experienced workers, workers that are familiar with the business, the process, the policies. And we actually see this as a win-win for both the worker and the employee. So I just wanted to put that on the record, because a lot of times we talk about creating jobs, and the issue is not the jobs. The jobs are there. The issues are the wages. You know, it's what people need in order to succeed and have viable life standards. And this is the feedback that we're getting. So that there seems to be a little discrepancy in what, and I won't say discrepancy, just a difference, you know, in what your district is saying versus a district like mine. So I just wanted to put that out there. There are many sides to this, and I do appreciate you, Senator Fazio, coming today to share your perspective on what you believe the impact of this bill would be.
Thank you.
You're welcome. Representative Aurora for the second time.
Thank you, Madam Chair. Since there were no other questions, I thought I would take the luxury or indulge. I would hope you'd indulge in me. I wanted to just, since we have Senator Fazio here, for maybe if he will spend another couple of minutes to address one of those things, something like these kind of restrictions, as they call labor restrictions on our labor market, would that actually hurt, you know, let's say one district which has more jobs available to be not able to hire from another district? So we were talking about a discussion, let's say, you know, there are jobs in Stamford, Connecticut, and there are perhaps, you know, workers in Norwalk, Connecticut, or Darien, Connecticut, or maybe Bridgeport, Connecticut. Would something like this have restrictions so that folks cannot really hire new folks where there may be more unemployment or more lack of opportunity in some of the other districts? Would you think that this is a reason, one of the reasons not to put such kind of labor restrictions would be to make sure that there is more fluidity, so that maybe in Bridgeport or New Haven or in Norwalk or maybe in Greenwich, if there are more people who don't have jobs, they can go to Stamford, which may have more jobs. Your thoughts on that idea?
I have a great deal of confidence that a restriction like this would reduce the demand for labor, reduce jobs, and reduce wages too, because it imposes a new liability on small businesses that are already having difficulty creating jobs. It says that you have to offer work to a very, very small number of employees in a state of over 1 million workers. And that just on its face has to reduce the number of jobs that are created and the speed at which they are created. And demand for labor is going to equate to more jobs. It's also going to equate to higher wages, because it's how productivity is created. It's how work experience and human capital is generated. And the more human capital, the more full-time work there is, the wages are going to be higher in the long run. And you have to be concerned most of all about long-term wages, not just short-term or nominal wages, as the current inflationary spike is showing us. So I do have a great deal of confidence that a law like this being extended and other laws are going to reduce wages, and they're going to reduce jobs in the areas that need them the most.
Thank you, Senator Fazio. That's a very important point, I think, to keep in mind as we as this committee looks at this these rules and laws, that not only does it hurt job creation, but these restrictions may actually hurt the areas and the neighborhoods and the communities which we want to help most, which are suffering most, not just the ones which are suffering least or like to like. I said once again, you know, at the extent of repetition, thank you very much for these insights you bring to the committee. Thank you, Madam Chair, for a second recognition.
Thank you. And thank you again, Senator Fazio. Up next, we have Patrick Hewlin from the Governor's Office.
Hi, Madam Chair. I thought there was a change to the speaker order, and I was going to go after DOL. Maybe I'm wrong. I can go now. If needed.
Can I
will recognize Senator Kushner.
Yeah, I apologize, Patrick. I know you made that request. We don't like to change the speaker order. But what we have had happen in the past is people can't get on at a particular time, they come on later. But since you're here and you are on the agenda, I think you should go first. Thank you.
Okay, thanks. I was going to bring up a couple of kind of national experts with me, but if that's not possible, that's okay. They're not available till 10:45. I think they're both teaching right now.
Well, that is possible. So if that is the case, we will go ahead to Mitch Goldblatt. And once your people come on, if you can just let us know, we'll call you once you have your people available.
Perfect. Thank you.
You're welcome. Thank you. Up next, we have Mitch Goldblatt, Town of Guilford, Director of Human Services.
Mitch Goldblatt doesn't seem to be there, so we'll move on to number 4.
We'll move on. Thank you. Up next, we have the Honorable Beverly Straight Kafalis, Probate Court Administrator. You have the floor, madam, if you are with us. I see you.
Good morning. I'm sorry.
Good morning.
I lost my connection there for a moment, so my apologies for the delay. Good morning, Senator Kushner, Representative Porter, Senator Sampson, Representative Aurora, and distinguished members of the Labor and Public Employees Committee. Thank you for the opportunity to testify before you today regarding Senate Bill number 209, an act concerning the status of probate court system employees. I am Judge Beverly Straight Kafalis. I am the probate court administrator, and for over 20 years, I served as the elected judge of probate for the Milford Orange Probate Court. Although similar proposals as this one have been raised before the committee in the past, I believe it's important to be reminded of the unique structure of the probate court system. In 2009, the legislature approved significant reforms to our system that modernized and professionalized the system. The reforms were effective in January 2011 and were not limited just to the significant consolidation of the courts from 117 probate courts to the current 54, but it also enacted and created the Probate Court Budget Committee with the sole jurisdiction to set compensation and benefits for the probate court staff. It is important to know a number of key factors. First is that wages and benefits as a result of this reform are in fact now uniform across all of the probate courts. Prior to these reforms, there were literally 117 disparate and unequal compensation plans and benefit structures because they were set by each individual probate court. They are now, in fact, uniform. And what had happened in the past, which was of huge concern to many of us, is that those structures for compensation and benefits for the probate court staff was often tied to the wealth of the community in which they served. So clearly, wealthier communities were paying higher salary, providing better paid time off than other communities with less financial resources. It was inappropriate, and the reforms that this legislature approved in 2009 were welcomed by many of us. The Probate Court Budget Committee, since it convened in 2011, has consistently approved cost of living adjustments, merit adjustments, and salary compression adjustments when the legislature has approved the requested and needed general fund appropriations, and when the probate fee revenue, which right now represents 75% of our operating revenue, have flowed in at budgeted levels. I've been fortunate as administrator that not only has the state budget as a whole, but also the probate court system has been strong enough so that the Probate Court Budget Committee has consistently approved those COLAs, merit adjustments, and salary adjustments since I have been, and prior to my role as administrator. Another unique factor about the probate court system is that probate judges are the individual employer of the staff of their respective districts. They are elected officials, and similar to the legislature, which is not included in the definition of employer and employee set forth in Connecticut General Statute 5-270, they serve and are elected by their respective communities. A factor that I think is significant to note as well during this public health emergency is because of the Probate Court Budget Committee, it convened immediately emergency and special and conducted its regular meetings, which are public and open to all to attend and offer comment. And they implemented and approved emergency compensation plans directed specifically to protect the health and safety of the probate court staff. And so that they did not lose wages when they had to stay home because of health risks or childcare issues, school closures, and the like. The Budget Committee nimbly and quickly implemented these extraordinary paid time off benefits to ensure that the physical and the fiscal health of our probate court staff was protected throughout this public health emergency. They were able to safely cohort or stay safely home and not lose wages or a position as a result of the public health emergency that has strained each of us. I raise in my written testimony, as I have in the past, a number of serious questions with the proposal before you, aside from the concerns about making sure that the uniformity of wages and benefits that was part of the 2011 restructuring are maintained. For example, probate court clerks are not required to be attorneys, unlike their relative equivalent in the Superior Court. Superior Court clerks are attorneys, unlike in our system. Would that then become a requirement if they were to be parallel to their judicial branch state employee counterparts? Other issues that are of concern is there are presently 60 different courts. There are the 54 local courts and the 6 regional children's probate courts, each of whom are the individual employers of the respective staff. And as you know, as legislators, the court staff not only have to be proficient and very skilled as they are in the legal knowledge to meet the constituents' concerns, but they also must be sensitive to the very concerning, often grief-stricken circumstances that bring the public to the probate court. Their compassion, their sensitivity, their attention to the personal and the legal needs is a very critical component of what the probate court staff offer the state of Connecticut, just like your legislative aides. And I would not want to lose that aspect of their commitment to our system.
Thank you, Honorable Street Kefler. Well, it's actually been more than 3 minutes. But we will open the floor to see if there are any questions. And I do see we have a hand raised from Representative Aurora, and you have the floor.
Thank you, Honorable Street Kefler. Sorry if I get your name wrong. If you want to just complete your thought, I know you got cut off right there. If you'd like to just complete your thought there.
Well, I do have written submissions that certainly outline in a little bit more detail some of the concerns. And so I would just ask this committee to consider all of those issues as well as the important reforms that have been undertaken to address some of the concerns you have heard about. And I just ask your consideration in that regard. Thank you.
No, thank you so much for testifying, and providing input into this bill. Is there something broke that we are trying to fix? Is there some, just as you said, that there's in any compensation system, in any employer contract, there's always things which can be fine-tuned to make them perfect or make them better. And we realize that, there is, I'm told that there is some issues which might need to be addressed. And as you said, they are being addressed. Is there something systemic which is broken in your mind, why we are taking this up or why we have this pressure to take this up?
It's my perspective, not only as the administrator, but as having served in the system for many decades, is that we have accomplished significant reforms and modernization and professionalism in the probate court system with the reforms that took place about 10 years ago. Not only do they significantly save the state over $4 million every single year, it really was critical that the uniformity of the wages and the benefits was part of that reform structure. And the probate court budget committee that convenes regularly, and as I said, very quickly, there were a number of emergency meetings convened in the beginning of this public health emergency to make sure that the court staff maintained their physical health, their family's physical health, but also didn't have a loss in compensation. And it quickly approved extraordinary paid time off to meet those needs. That nimbleness, that agility, and most importantly, the recognition of the value of the probate court staff, I think is really just a model of an excellent structure. The probate court stayed in operations throughout this public health emergency. The probate court staff made sure the public's probate needs were met day in and day out. And I think the budget committee has recognized that with ensuring those extraordinary benefits.
Thank you. Thank you for that insight. A question, but if something like what is proposed in the bill were in effect, would that have led to a really much worse outcome during the pandemic and would have led to pretty much an inability for you to do what you need to do and to serve the public of Connecticut?
So one of the questions that's really unanswered by the proposal as drafted is that there are right now 60, in essence, units, 60 probate courts that employ the staff. And there's a question about whether the jurisdiction and the authority of the statutory probate court budget committee would be changed if those 60 individual units then had a role in setting wages and benefits. The value of the reform is that they were in fact centralized by one structure that is a public organization so that one community didn't have a better benefit than another. And that's what happened and had gone on for far too long in our system prior to the reforms enacted in 2009.
Well, thank you very much. And, I appreciate your input and, I will yield here and perhaps maybe as the discussion goes on, might have another question or so. Thank you so much for your testimony.
Thank you.
Senator Kushner, you have the floor, madam.
Thank you, Madam Chair, and thank you for being here today and testifying. We really appreciate your input. But I was listening to your last comment. Clearly, in drafting this, we are concerned about making sure that there's a voice and a mechanism for that voice to be democratically expressed by employees. I hear your concern about the possibility of, many different units and the concern that there could be disparate benefits negotiated across different units. And clearly, I don't think that's the intention or the purpose of this particular proposal. So if we were to be able to address that, would that improve the bill in your opinion?
I would say candidly, I'm open to all discussion about whatever reforms the probate court system and the legislature feels will benefit the state of Connecticut as a whole. I can't say that that's the only concern that we have. I do feel strongly that the probate court budget committee structure is in fact a democratically organized structure. The legislature created it with the 2009 reforms. It is a public meeting at which all court staff, judges, and the general public can offer comment and feedback. And I think that's an important component of that structure that did not exist prior, again, to the reforms that this legislature approved.
I appreciate your response, and I do look forward to working with you to, making the bill hopefully something that everyone could embrace and support. Obviously, when I referenced more democratic, I was referencing the voice of the employees, and I think that collective bargaining throughout the U.S. history has proven to really provide the best mechanism for creating that democratic structure in the workplace. But I don't want to leave on that note, because I really want to thank you for all the work that you outlined that was done during the pandemic. And we are aware that probate court employees stepped up and were, really able to continue functioning to the benefit of our residents here in Connecticut. So we appreciate the work that your courts do. And so thank you for everything that you and the workers and the judges did to keep us operating in Connecticut.
Thank you, Senator.
Thank you, Senator Kushner. I will echo the sentiments that were just expressed. We are truly grateful for all the hard work of the probate court. A couple of questions. I wanted to know, are you all planning on raising health insurance costs in July? Because this is some of the conversation that we've been having on the other side of this. And if I could just get clarity on that from you.
So the state health insurance benefit is not established by the probate court budget committee or my office. It is negotiated by the office of the state controller, and the probate court judges and staff's entitlement to those state health insurance benefits is set by statute.
Okay, thank you for that. And then this is the last question I think I'm going to ask is, were probate employees given the ability to work from home during the pandemic?
Unfortunately, because of the confidential nature of much of the probate court processes, they were unable, we don't have the technology or the secure systems to allow them to work from home. So in the alternative, the probate court budget committee, as I shared earlier, approved compensation, extraordinary compensation, so that even when they were cohorting, they were paid at their full regular wage.
Thank you for that response, Honorable Street Kafalis, and I hope I'm pronouncing your name correct as well.
That's why everyone just says Judge Beverly. It's Strite Kafalis, okay, but it's a mouthful. Thank
Strite Kafalis. You're welcome. Yes, Representative Aurora for the second time.
Thank you, Madam Chair. Judge Beverly, Honorable Judge Beverly, can you please provide for the benefit of the public as well as members of the committee, your expertise and your role, because, when we think about you as a judge, sometimes some may basically assume that you're one of the probate judges, but in your administrative role, you have huge insights into the entire system. So for the benefit of all, can you just talk maybe a couple of minutes to that as to how you really see the entire system? You kind of understand much more than anybody in the committee would ever, the intricacies of how the system works. And so that when you say you provide your suggestions, we need to weigh them and give them quite a lot of consideration, considering your background and what you bring to the system or what you do for the system.
Thank you, Representative Aurora, for the question. And I know that time is a concern. I could probably talk for hours about the role of the probate court system in our state, what the role of the Office of the Probate Court Administrator is. My apologies, I thought my phone was on a do not disturb new phone system, which I haven't learned. But in essence, the Office of the Probate Court Administrator is to support the works of the probate courts. We have an IT department, a legal department, and the financial services department. But each local probate court operates independently to the extent that each judge is an elected official, just like a legislator. And they hire their own staff, but they are not, because of the reforms, again, that I think are so important, The uniformity of the wages and benefits are now through the probate court budget committee. But the hours anyone may work is between the employee and the employer. And we offer the oversight in terms of legal support and structural support. The probate courts deal with such sensitive matters, as many of you know, guardianships of minors, when parents have health issues, whether it is a physical health issue, a mental health issue, a behavioral health issue, those family matters come before the probate court. Psychiatric commitments of individuals who are gravely ill will come before the probate courts. Everyone thinks about the probate courts as the court of trusts and estates, and yet over the past many decades, significantly more of the time of the court is spent on those social service and critical needs of our communities. And that awareness and local connection that each probate judge and the court staff that works in the local court is very important. They know their local communities, they know the families that come before them, and they make sure that their legal needs and their personal compassion needs are duly met. And that is, I think, one of the most stellar characteristics of the probate court system in Connecticut.
Thank you very much, Judge Beverly. We appreciate your testimony, and you know, I do hear that this bill will bring quite some unintended consequences. The system works. Perhaps the concerns need to be brought to the current process rather than hammer something new onto the system. But I do really appreciate you providing the perspective, and perhaps on an offline, you know, we might reach out to you with some more questions. Thank you to you, and back to you, Madam Chair.
Thank you. And yes, Your Honorable Beverly, I'm gonna go with the flow here. Certainly looking forward to having further conversations, because I don't believe that this bill hammers anything. I think it is actually looking to expand on what's being done to make it better. And it is always in our interest as labor co-chairs to make sure that we're addressing the issues that come before us. So thank you again for coming before us and testifying and sharing your concerns. And as myself and Senator Kushner have stated, we do look forward to having further conversations and discussions with you around how do we get to a happy medium.
Thank you very much, all of you, for your time and your dedication. Have a great day.
Thank you. You as well. Thank you. And I have been told that Patrick Hewlin is actually ready with his team. Yeah. So we will go ahead and give Mr. Hewlin the floor, to be followed by Mitch Goldblatt. Patrick, you have the floor.
Thank you, Madam Chairwoman. If the clerk could just admit Terry Gerstein and Rachel Arno-Richmond, and we'll all go in 3 minutes.
Thank you.
Get started. So Senator Kushner, Representative Porter, members of the committee, good morning. My name is Patrick Hewlin. I'm the Governor's Associate Policy Director. I'm here with two national experts, Terry Gerstein from Harvard Law School and Professor Rachel Arno-Richmond from the University of Florida. We're testifying in support of House Bill 5249, an act concerning non-compete agreements. And before I hand it over to them, I just want to note that a number of national experts have filed written testimony in support of the bill, and I encourage the committee to take a look at it. It's well supported by data and academic research that folks have done over the last couple decades. And with that, I'll turn it over to Terry Gerstein to flag a couple of critical points and then take any questions you may have. Terry, could you introduce yourself?
Sure. My name is Terry Gerstein. I'm the director of the State and Local Enforcement Project at the Harvard Labor and Work-Life Program, and I'm a senior fellow at the Economic Policy Institute. I'm giving this testimony in my personal capacity. But before my current position, I worked for over 17 years enforcing workplace laws in New York State, including as the Labor Bureau Chief in the AG's office and a Deputy Commissioner in the State Labor Department. And I became familiar with the issue of non-compete agreements when I was the Labor Bureau Chief in the State AG's office. And we started learning about non-competes and workers who were low-wage workers, who were rank and file workers, not necessarily super low wage, but like very, people who were sort of middle income living paycheck to paycheck, who were covered by non-competes in ways that were really abusive and that really constricted their ability to live their lives. We had a case involving reporters for Law 360. We had a case involving a phlebotomist who drew blood for medical service, who couldn't get a job where she was going to be working more stable hours and not having to travel as much. We looked into and resolved a case involving Jimmy John's, the sandwich shop. And after I left the office continued doing more cases, including involving WeWork employees. And, you know, economists, you may be familiar with, and I'm sure Professor Evan Starr has provided testimony. Economists have really documented the prevalence of non-competes and their impact on people, but there's also really a human impact on people not being able to move on. And, you know, just imagine what it means to be stuck in a job you don't like, because you'll get sued if you get a new job. Or if you have an idea to start a great new company, but you have to leave Connecticut in order to do that because you have a non-compete. I've heard a lot in the hearing today about growing the economy and creation of jobs in Connecticut. And I think it's useful for people to know that research shows that when non-competes are strongly enforced, that reduces new firm entry by 18%. The firms that do start have fewer employees at launch. They stay smaller. And so there is a real dampening of entrepreneurship caused by non-competes. And that's why groups that work with entrepreneurs like the Economic Innovation Group have spoken out and have opposed non-competes. This bill does a lot of—
Sorry, could I just ask you to hand it over to Professor Arno Richmond?
Sure, I'll hand it over to Rachel Arno Richmond, but this is a bill that really would take a lot of important steps in curbing non-compete excessive use.
Yeah, hi. Thank you for hearing my testimony. I am Rachel Arno Richmond. As Patrick said, I am the Rosenthal Chair in Labor and Employment Law at the University of Florida. I've been a professor of law in the area of employment law and contracts in particular for over 20 years, and I've taught, researched, and written about the law of non-compete enforceability throughout that time. I'll just add that prior to entering law teaching, I was a management side attorney representing business clients in labor and employment matters and commercial litigation. I support this bill. I find this bill to be an impressive balance of interests between employers and employees on an issue of increasing importance. And I'll just add, I'll be happy to answer questions, but I'll just add a few points to what Ms. Gerstein said about the dangers of non-competes. The problem with non-competes are multiple. They do not just affect employees who sign them, although that is one of their adverse impacts, preventing workers not only from leaving their jobs and going elsewhere, but also from their ability to negotiate for better terms of employment within their existing job, because the way to do that successfully is generally to threaten departure. They also adversely affect the economy and other employers. Terry mentioned—
Excuse me, your 3 minutes is up. Can you please wrap up?
Oh, I'm sorry. I didn't realize this was a 3-minute window. Okay, I'll reserve for questions. I wanted to wrap up by saying that non-competes also adversely affect employers who want to hire other workers and have the negative outward effects on the economy as a whole that Ms. Gerstein mentioned. And I'll reserve time, or I'll take questions on the way the legislation achieves that balance.
Well, thank you both. Well, thank you all three, Mr. Holland and Ms. Gerstein and Arno Richmond, for your testimony and for making the time to be here today. I do see that Senator Kushner has her hand raised, so I will recognize you at this time. You have the floor.
Thank you, Madam Chair. And I want to thank all of you for— I think it's particularly important and interesting to me, as somebody who has worked on the labor side of these issues, to hear from a management attorney who represented employers regarding these issues. And so, you started to talk about the problems of non-competes, and we kind of ran out of time, but I wondered if you could pick up there, because I am it's a perspective we don't always get in this committee. And it's very helpful.
Yeah, so the risks to employers of overbroad non-competes are primarily that it impacts their ability to hire new labor. And this is a particular concern right now in which we're experiencing a serious labor shortage. We want workers to be able to move freely because we don't want them to be restrained and worry about sort of the indenturing of workers to particular jobs. But we also want new businesses to be able to grow. So non-competes, as Ms. Gerstein said, impede workers from leaving their job to start a new company. They also then prevent workers who form companies from hiring other workers. And this is true even in the general economy of stalwart companies, not just in startups and sort of innovative new jobs. It's very difficult to hire in an environment when you are at risk as an employer of bringing someone on who will then be subject to litigation and potentially being sued yourself. Now, in fairness, I want to be clear. I understand that business interest tends to support the continuation of non-competes. So that is generally their primary concern. But the thing that this bill does quite well is really balance those interests. So the primary interest that business has in maintaining non-competes is the ability to protect proprietary information, legitimately protect proprietary information that could depart with a departing employee. And so this bill, I think, is crafted quite narrowly to enable non-competes where they are appropriate and justified by business needs, but to prevent overreach, the kind of non-competes that Ms. Gerstein was talking about.
Thank you so much for that helpful information, particularly your last comments about proprietary information being protected. I do want to ask Ms. Gerstein if you can say a little more about the non-compete agreements, the cases that you had in New York. And I want to specifically say that we started working on this issue a few years ago. And one of the things that was remarkable and that kind of surprised me was when I heard that there were fast food companies that were using non-competes, and we kind of all were making fun about the proprietary nature of the McDonald's special sauce, but that was it was something to joke about, but in reality, it's nothing to joke about. And I was curious. You mentioned that you had a case, a sandwich shop case, and I think it's really inconceivable to us on why there should be non-compete agreements for these kinds of workplaces and these kinds of workers. So if you could talk, I'm curious what the rationale was that was used by the employers, and then how it impacted the workers. If you could talk a little more about that.
So it is true that there have been non-competes, and we had cases involving non-competes with low-wage workers. There have been cases with dog walkers, with people providing childcare, like all kinds of work that, janitors, interns, people doing summer internships. The cases that we had, for example, one of them involved Law 360, where they had journalists who were right out of college doing their first job. And basically, to the extent there were, the idea that there was some proprietary special sauce, it was like LexisNexis, it was, going to the courts, like there was nothing. But I think that, that there was this sense of like, well, we've developed this special system, but then when we sort of, in our investigation sort of pressed about it, it just, I think often employers use it as a way to, what they're supposed to do if they want to keep employees is give good working conditions, provide a career ladder, be competitive in providing good wages and benefits. And instead, employers use this as a way of just not having to do those things, but keeping your staff. And so that was one example. The one that I mentioned before was someone who was like traveling throughout the state, drawing blood, and got another job where she would have to she wouldn't have to travel as much and could stay in the same place. The Jimmy John's situation, the stores in New York State were actually all franchises. And so the way our case got resolved was that Jimmy John's, the franchisor, basically agreed to stop sending this material to franchisees, and they would tell everyone that, these aren't effective anymore. But the state of Illinois, where there are corporate stores and corporate employees of Jimmy John's, the state of Illinois, if I'm remembering correctly, the AG's office there actually sued Jimmy John's before reaching a settlement. I think it's very hard to justify in these kinds of situations. I guess, with some of the dog walker situations, maybe it's, customers and, relationships with pet owners. But again, dog grooming and dog walking, it's not the kind of thing that, it's hard to imagine a legitimate business interest in preventing someone from walking dogs.
I appreciate your answers to these questions. And I think the other point that you highlighted that I had not really considered, hadn't really been in the forefront of my consideration about this bill is the fact that it restricts people from leaving. I thought about how hard it is when you leave and you have to go somewhere else, but restricting people from being able to leave their job is something that I think most people would find very objectionable. So thank you both for your testimony today, and thank you, Patrick, for bringing them to us. That's all I have, Madam Chair.
Thank you, Senator Kushner. Representative Aurora, you have the floor, sir.
Thank you, Madam Chair, and thank you, Professor Gerstein. Thank you, Professor Arno Richmond, for your testimony. I actually think I agree with you for the most part, because I do believe that there are employers who use this as a tool to do the wrong thing, right? And we need to discourage that. And I think the discussion, I would like to take your expertise here, and I'm so glad to have it here, is to figure out how to make sure that we do not have unintended consequences, because you laid out, you have worked for large firms, and you have learned, I think you mentioned you had worked for other firms, that the proprietary information is not all a mirage, right? And we can discuss that in detail. But I think the focus here is that the tool or the methodology this bill is using is 3 times minimum wage or 5 times minimum wage for independent contractors. And that is the kind of thing which is a little bit, it appears there may be a lot of collateral damage there. Now, I think we could mostly, and I speak for myself, not all my colleagues or other caucus or other members of the committee, is that when you come to defining it a little more kind of in a manner which is quite clear, and this is an opinion I would like from your expertise, let's say minimum wage, right? It's very hard to say you're giving proprietary information to a minimum wage worker. I think, I think it's a pretty ludicrous claim. You're going to pay somebody minimum wage, and then you're going to provide them the secret sauce. It's highly unlikely. So we feel safe that the unintended consequences are low. Would you kind of agree? Would you agree with that assessment, that that's the safety in some sense in a legislation like that, where there would be no unintended consequence?
So I take that question as going to me, and I really appreciate that comment, and it is something that I've thought about quite a lot. So the legislation operates on a number of levels. Non-competes are extraordinarily complicated. The interests at stake, the economic impacts point in many different directions. And there are lots of different problems, there's different layers to the misuse of non-competes. So the representative is completely correct. The strongest case for barring non-competes is with respect to truly low-wage workers. And that's one of the things that this bill does. And there certainly can be legitimate differences in how it's best to define low-wage workers. And that's not something I'm going to opine on as an outsider to your economy. And that depends on your internal legislation in Connecticut and, the cost of living and other considerations that each jurisdiction is going to have to make for itself. I take the representative's point to be in part that in drawing that line, it should be a line that makes sense economically, but also administratively for employers in terms of how they are able to sort of easily classify which workers are not or should not be subject to non-competes because of this law. But there is another area of concern, and this is where things become even more subtle, and that is the overuse of non-competes or the overbreadth of non-competes that are used in with respect to middle-income workers. And the challenge is how to separate out those legitimate uses for employees that have the secret sauce and those employees who just have access to the usual information that any individual might have within a company. And so, there are a couple of pieces there that we need to be mindful of in crafting that balance. And this goes in part to unintended consequences. When Senator Kushner asked, why do we have non-competes with respect to certain jobs that seem to make no sense in terms of our understanding of the interest? Part of the reason, as Ms. Gerstein said, is that employers are using these instruments opportunistically to retain workers. But part of the reason also is that some employers are operating in good faith, but they have large departments. They have, massive numbers of employees. They have HR departments who find it convenient to use a single form for all of their workers. So part of the problem is that it's just too easy for companies to paper the employment relationship universally without giving thought to the particular needs with respect to individual workers. And while that, one might describe that as a problem in general in terms of the position of workers vis-a-vis employers in our society, it resonates and requires action in this particular context because underlying this is a concern about restraints against trade. Restraints on trade. And we have to remember, at the risk of taking the position of a professor, and I think it's important to remember a bit of history and the background common law that this legislation is addressing. The background law is that these restraints are void. They are void for a reason because they are facially restraints of trade. And so non-competes are a narrow, permissible non-competes are a narrow path that employers may take provided there is a genuine concern and that they are protecting, and on top of that the scope or reach of the agreement is just not too far, that it will have these public policy effects as well as the effects on the worker. But that's the framework. So there is a line drawing that needs to be done, but I want to start by just suggesting that it is imperative that it be done, because if we're talking about unintended consequences in each direction, it's the unintended consequences in restraint of trade that we should be most worried about, given the underlying public policies and the history of the use of these documents. Now, to the point, if I may, and I don't want to monopolize the floor, but I take that there's another question there with respect to how that balance gets struck in companies as a practical matter. And what I think this bill does very, very well is it clarifies common law, but it preserves, preserves all recognition of all of the interests that employers might legitimately have. It recognizes trade secrets, it recognizes, of course, customer interests, it recognizes confidential information. It also recognizes the need to restrain those agreements within a reasonable bound and for a reasonable time. What the legislation does do is it encourages, it places a cap, if you will, the one-year cap on what reasonableness can be, so that we have sums and an area, the area in which the employee worked, so that we have a starting place for what reasonableness means in a way that both employees and employers can rely on the law in terms of what is and isn't enforceable. The other thing that the bill does that I think is very helpful to employers is it specifically preserves the ability to use these other types of less restrictive instruments, and in fact encourages employers to use things like non-disclosure agreements and so forth to protect those interests that are at stake. And beyond that, it makes no change to existing law of trade secret protection. And so employers are still permitted, of course, to pursue misappropriation of information through the tort law. So those are just some of the aspects in which I think the bill does a nice job of striking a compromise.
So no, I really appreciate your input. I really do. I think the question which I would like to ask you in a little more your expertise is just the one about where and how we draw the line and what is safe. Because I always consider with and I'll put point of view of many legislators that we don't want to do harm either. We want to take the what you call low-hanging fruit where we can do good, or we can. And so, for example, many members I've spoken to say, well, minimum wage, agreed. That's easy. That's a straightforward one. If you are going to pay somebody minimum wage, you better not. It's by definition, it's clear. Now, this is where it becomes really difficult and in very competitive businesses. So think about a franchise business where I had a conversation with someone. They said, well, it's so difficult if I lose my manager here and he doesn't give me or she doesn't give me 6 months or a year. I'm done. I put my life into this. I don't pay them, the 3 times minimum wages, something like $95,000. Some years they may earn more than $95,000. Some years they may earn less. It's just, you got to give me some room here. I'm going to be done. It's 10 years of my life I spent building this in this location because I know there is a location out there. I know we figured out how to be profitable over years. All my other workers are going to be gone because there's much stronger relationship she has with as stronger relationship. She may give them, the whole business is at risk. And I listened to the person and I said, well, that's a good point that this person does have proprietary knowledge in that sense. And in a year, and what their point was, over a period of time, it dissipates. Or they will have the ability to train somebody else, get it going, and so on and so forth, rebuild the business around somebody else, and so on and so forth. So one of the questions which we really believe is that there's many such most competitive business. As a matter of fact, if you're a Microsoft or if you're a Google, you don't care. Right? It's much less. You're already operating in a 300,000 or 150,000 or a much higher. So my question to you, your expertise would be, how do we make sure that, or let me ask you in a different way, that do you see a number of competitive businesses which would get decimated or very hurt in something like this? I don't know what they will do is they will try to keep. One response would be keep them over 3 times minimum wage. That's what I heard them say, right? It's just like we are trying to fix wage for anybody who's basically got any amount of proprietary information, because otherwise it's legally not right. That's one of the questions I want your expertise. We can do less harm by just defining. If there is the onus of defining proprietary nature, you cannot misuse it. We all agree with those kind of ideas. But this law, the way it's written, I think the safest would be to make sure that we do not get these unintended consequences. And any ideas how to make sure that that person, for example, in that situation gets protected? And to either one of you, I know perhaps Professor Gerstein, you could answer this. I want to make sure we hear from both of your viewpoints as well.
Well, I was going to say, I think Ms. Arno Richmond might be a better person to start talking about it, but I can share. Also, I'm not a professor. I just want to make that clear. But I just want to, I mean, one thing that I would say about this is that some of the concerns about non-competes really apply for workers at all different levels in terms of their impact on creation of businesses, their impact on innovation. You might have mid-range workers who want to start their own business, not necessarily across the street, maybe a town over, right? But who are not able to do that. And innovation and competition is sort of what our economy is based on. And so to the extent that they limit innovation, entrepreneurialism, to the extent that non-competes limit job mobility, to the extent that they depress wages, all of those impacts happen when you're affecting middle wage workers. I would also say that the bill does provide other tools for protecting the employer's proprietary interests, as Professor Arno Richmond mentioned. The other thing also, just on a more like human level, is that it is not only people at minimum wage who are living paycheck to paycheck. If you do the math, I think that, 3 times the Connecticut minimum wage, if you annualize it, gets you to sort of somewhere in the 80,000 range, roughly, which is not, it's definitely not a low wage worker, but that is still someone, if you have someone, a single mom who is supporting a couple of kids, $80,000, like that is someone who's living paycheck to paycheck, and to constrain that person's ability to earn a livelihood in the place where they live is something, setting that rate at a relatively, not a super low level, but kind of like a mid-high level, sends a clear, conveys clear guidance that this is supposed to be an outlying thing that happens when someone has a non-compete that requires individual consideration. Do I need a non-compete as to this particular worker, as opposed to something that's sort of blanketed across countries, across whole departments in a company. And I would also, just sharing a personal story. I grew up in Cromwell. I'm originally from Connecticut, and I have a relative who lives in central Connecticut who was making sort of in that 60, 70 range, a single mother with 3 kids, a couple of them in college, and was asked to sign a non-compete. This person had a pre-existing health condition, and she had been working for the company for some time and was sort of presented with a non-compete. And, we talked about extensively, she certainly had access to lots and lots of expertise about that non-compete. But in the end, she felt compelled, like she had to sign it because, she needed the health insurance, she needed to be able to continue to work and support her kids, and didn't need to fight with the employer. And again, this was a situation where there really was no proprietary interest. It was just a way of making sure that the person stayed in the job. And again, this was someone in the sort of $60,000, $70,000 a year range. So I just think if you think of how it impacts people, you think about the other protections for employers, and you think about the broader impact on the economy, setting the rate at an extremely, low wage worker only level just doesn't make sense. Do you want to add anything?
Yeah, thanks. I think that was great. And again, I just echo the last point. It is about balancing of different interests, and there could be unintended consequences in any number of directions here, and we have to figure out what's best. I just thought to respond briefly to Representative Aurora's sort of example about sort of the small business concern. And it's interesting because, and I know you were just, Representative, you were just sort of suggesting something sort of off the top of your head, but my mind was instantly thinking about that example of being a law professor, about the hypothetical, and wondering what the interest is in that situation. Because the way you described the franchisor or the store owner's concern, it was a concern about losing all of their people. And I want to be clear about this, because under the common law that exists now, that is not a legitimate interest deserving of enforcement. This law doesn't change that. It's already the case that we are not supposed to use non-competes. It violates our rules against against restraints of trade to make an agreement to restrain a worker from leaving, just on the face of it, to prevent that worker from competing. And so we have to remember the starting place. The problem is it's too easy for employers to ask for those kinds of restraints anyway. And they ask for them in part, not because they're necessarily trying to be opportunistic or violate the law. Management has and businesses have somewhat inflated ideas from time to time about what their proprietary interests are. They don't necessarily accord with the law. And it's too easy, as Ms. Gerstein suggested, for an employer to just put a piece of fake paper in front of a worker, have them sign, and then that worker is not able, it really doesn't have the capacity to question or address the legality of that situation, but is essentially handcuffed to the job because they can't take the risk of seeking out a lawyer or trying to, go through a litigation process, which would just be, impossible in a situation where you're trying to, accept other employment or search other employment. These agreements are a risk when you go on the market. Many employers, reasonably sophisticated employers, are going to ask you, hey, the job that if you have experience, that job that you were in, did you sign anything that might prohibit you from working here? So in that context, the problem with agreements that may be well-intentioned, but were not, are not actually hewing to the law is extremely problematic, and it's an extremely high-risk situation. So we have to really err, I think, in defining the policy here. It's best to err on the side of prohibiting potentially onerous non-competes or potentially illegal non-competes because of those concerns.
Yeah, no, I totally hear you. I have been on both sides of it over my career. I've been extremely upset over periods of my career being subject to them by an employer. And I have taken that to heart that when I was the employer, I wanted to make sure that they were most reasonable. And by the way, I found in both times, and I was in a specific industry, in both times, I found there used to be needed, but how they were implemented and how they were enforced is what the discussion was around. And here we're talking about, obviously, higher pay grades. And so to some extent, I thought that, that the government involvement, while I would have liked when it was against my idea, against my position, I did understand that, I was in a position that I should be negotiating it well in and out. But having not said that, what I'm saying in the example which we gave, or we were thinking, and specifically, there could be different kinds of proprietary information. And we're not just talking about the recipe. We're talking about what are the best places to source, certain goods. What is the, you learn, and sometimes, I've been in business where, you make a mistake for such a long time, and then finally you figure out, you call them kind of trade secrets or whatever you may, well, that's the right supplier. They deliver, they never fault. And now the person basically takes all of that learning for 6 years, the suppliers, where to reach out to for what happens when, certain situations happen, and certain buffer was required. And we can all disagree what is proprietary, what is not. And that's the question which we're saying. Are we here to make an assumption on proprietary nature based upon a cudgel, a very, very rough income definition? And the other thing which I really would like to ask is the idea that whether somebody's living paycheck to paycheck the relevant criteria, or is it the idea of what is proprietary? Because I want to point out, if you work for the federal government, if you work for a number of federal government agencies, you are subject to a very significant non-compete. I know people who do research for the federal government in some agencies. They could make 5 times the amount they were making, 5 times the amount, if they just crossed over to to a private agency, but they don't. And it's their duty, and it's what they signed up for. And, I don't know whether they make 80,000 or 90,000, but it's not that they're not making hundreds of millions of dollars either. So the government does it. The proprietary nature is important. What we're talking about is, how do we define proprietary? And I think the law should focus on that, rather than saying, well, anybody who makes 3 times minimum wages has got proprietary information, and that's just what the law should be. That's just a really what I would say very coarse usage of force, which could lead to a lot of unintended consequences. And the numbers may be small. There may be 500 businesses which go out of business around the state of Connecticut, but the employment concerns could be large, right? So, I just want again, maybe one more time ask you, do you think that we should focus more on a finer metric of proprietary nature? And we agree, and I agree that, the misuse should be stopped, and perhaps just even stating the intent that they should not be used, even a negative intent that it should be clear that they should not be used for retaining workers for non-proprietary reasons, something like that. Whereas a use which we are defining here could have a lot of harm in real businesses and real firms.
So I can offer some initial thoughts on some of those issues. One is that, the concern about jobs being lost and businesses closing. Again, the research shows that enforcing non-competes, that strong, in states where there's strong enforcement of non-competes, that actually reduces entrepreneurialism, reduces creation of new firms, reduces the firms that start don't grow as quickly. So that issue about job creation and about preservation of jobs, I don't know that there's any research out there that shows that enforcing non-competes causes businesses to go out of business. I don't think there is any data that demonstrates that in any kind of broad systemic way. But the research does show that it increases creation of new firms. Another issue in terms of the 3 times the minimum wage, as someone who spent most of my career doing enforcement, and now I work with enforcers all over the country at the city and state level, I've heard a lot from enforcement agencies, and in my time in New York doing enforcement, I heard a lot from employers that what is most helpful often in laws is having sometimes very clear guidelines. Employers say, I just want to know what the law is so that I can comply with it. And for enforcers as well. And if you want to avoid litigation, it's sometimes very helpful to have something that is very clear like this, 3 times the minimum wage. If you have a balancing test with, a dozen different factors that are continued, that's the kind of situation, or 15 factors, and it's all kind of a reasonableness, like that kind of situation can lead to a lot more litigation than having something that is relatively clear, like 3 times the minimum wage. And then the other thing that I wanted to add as well about that question, about people living paycheck to paycheck and where should the level be, as I already mentioned, these concerns about job creation and job mobility and wage suppression, they apply not just to the lowest wage workers, but also there are situations where people are facing, we know that there are widespread violations. Lots of research out there shows violations of our anti-discrimination laws, sexual harassment laws. We know that sexual harassment is far more widespread, I think, than many of us had realized. The overtime law applies to not just the lowest wage workers, but to a broader range of workers. And the overtime law also is aimed at different goals. Right? Reducing overwork, incentivizing employers to hire more people so that, instead of having one person work 80 or 90 hours, you have 2 people work 40 hours. And there are really, research shows there's really widespread examples, really widespread incidents of overtime violations, Equal Pay Act, et cetera. And so when people have a non-compete, it really hampers their ability to address those kinds of violations because they feel like, well, I have to stay in this job, even though I'm being discriminated against or sexually harassed or paid less than someone next to me or not getting overtime because I can't get another job in my field. So it's sort of, to the extent there's already widespread incidents of certain kinds of workplace violations, non-competes really exacerbate that. And again, that impact is not limited to people at the lowest end of the economic spectrum.
I really do appreciate that point, that making it more objective enforce it, and so the enforcement is not a matter of legal kind of to and fro, especially for those who are making, even just as you said, 3 times minimum wage. I really appreciate that. I think that's a very important thing, which I think all of us should really, at least my appreciation for that is really large, because I do think, keeping it at a more objective level rather than a subjective level is beneficial. It's just that for independent contractors, we are putting it 5 times. That's why our objective is basically, hey, maybe minimum wage. So I agree with you. Let's just keep it objective. And then when you're keeping it objective, you want to say, let's make sure that there is no harm. Because one of the things I would like to ask you is, you mentioned there is no research about non-compete. The question is not about non-compete. The question is about proprietary information. Right? Non-compete is a way to protect proprietary information. If you said, well, there is immense amount of research which shows that if we had no IP laws, we would have created, especially in an economy where we headed to, knowledge-based economy. So when I think about non-compete impacts, used correctly, right? We both agree. I think there is no disagreement here in my discussion here, or in our discussion here, that they should be only used appropriately when they protect proprietary information, and when it is very clear that and the understanding what is proprietary can be, obviously, just a professor mentioned, can be kind of a little bit subjective, but that is how it is. We cannot put objectivity into something which is subjective. So I do want to point out, and maybe I want to solicit your information, that IP and proprietary knowledge, there is an immense amount of research that weakening the institution of proprietary as well as intellectual property would be extremely harmful to our society overall, and lead to, and I wouldn't even term in terms of certain specific job loss. Our economy is entirely headed to and based on intellectual property. So this is in some ways, really saying that some ways of protecting intellectual property are not okay.
So I'm going to interject really quickly, because we are past the 1 hour mark where our public gets to weigh in. We're going to start rotating back and forth. I want to thank those that are waiting in the public for your patience. This has been a very, productive conversation going on. I will give you the floor to answer that question, but I will also say, Representative Aurora, I'm sure that Mr. Hullen would be more than happy to arrange a time where you could further discuss this as a sidebar, so that we can be, we can recognize people's time. So please answer this question, and then we're going to move on. And I actually had some questions as well as Senator Kushner, but they have been answered, with the exception of one question that I have. So I would like to have an opportunity myself as the chair to ask one question before we move on to number 7. And I do see Mr. Goodbaum being quite patient and waiting. You will be up next, sir, after this. Thank you.
May I respond just briefly to the intellectual property?
Absolutely.
Okay,
Absolutely.
Thank you.
Thank you.
Yeah, and there is a great deal of data, and we've already, I want to be mindful, we've already gone over this, that in terms of the innovation and development and R&D and all of those concerns, that non-competes actually do stifle that type of development. And of course, California, Silicon Valley is the sort of the emblem of where that type of innovation occurs. And of course, in California, non-competes are banned. So, and there's data on that, which we can provide to you. But the other point I wanted to make with respect to intellectual property is, one of the problems with non-competes is that they skew the intellectual policy balance. Intellectual property is designed, copyright law, patent law, all of these regimes are designed to balance the incentive to innovate with the need to share information, which itself creates innovation and allows the public to have the benefit of that information. And that's why we have limits within copyright law for how long we can have copyright. That's why we have high bars to entry to demonstrate patent. And that's why we have very strict definitions of what a trade secret are in our background law and our regulatory law and our common law. And so really the problem with non-competes is that they disrupt that balance. So I would push back on the idea that this is eliminating a sort of a way of protecting intellectual property that employers need or is even sanctioned. The policy lines that we've already drawn, I would suggest, are being disrupted by these instruments. And those concerns, to my mind, very much point the other direction.
Thank you. Was there anything that you wanted to add, Ms. Gerstein?
No, I'm good.
Thank you. And my question is really quick and I believe really easy. I wanted to know, because of how this conversation has been going, and it really is centered around the worker, and what this causes, right? The impact on the worker and their ability to be mobile. In your work and in the cases that you've represented, can you tell me, has the employee always known that they have signed a non-compete agreement? How many workers have actually signed these agreements and had no idea? Because you did say employers are aware, and they're even asking the question on an interview. But are employees really actually able to answer that quite honestly? What has been your experience?
So often when workers start a job, they're just sort of presented with a whole bucket of paperwork to fill. And it might be on a touch screen, it might be physical hard copies of paper. Generally, there's not, again, when we're talking about not super high level employees, but just sort of ordinary workers, there's not generally negotiation. It's sort of take it or leave it. People are often not informed that they have a non-compete until after they've already started a job or on their first day. And so it's not the kind of thing where they negotiate and they get some additional considerations. They get more pay because they're giving up this, the right to, because they're making a concession by accepting a non-compete. And again, in the sort of flurry of touchscreens, often people don't know, they don't know they've signed a forced arbitration agreement. They don't know they've signed a non-compete. People are really unaware of the rights that they end up giving up when they start a job. And so I think that question is a very good one. And it's very common that people don't know, aren't aware that they have a non-compete. Professor Arno-Richmond, do you have something to add?
Oh, I completely agree with that. Our best estimate is that maybe 1 in 4 employees has at some time or another been subject to a non-compete. And that includes many workers who don't even have a college degree. So there's no question that they are being used in many, many situations that probably do not involve proprietary information, right? So regardless of what the cutoff is for where we might make that assumption or not, it's very clear that there is overreach in the use of non-competes. And what I would add simply is that, one of the, this is a very smart and careful bill. And one of the things that it does is try to address that very problem by forcing the employer to provide the non-compete in advance with information about what the document is. And that is irrespective of, that has nothing to do with the wage threshold. That is where non-competes are permitted. That is, employees satisfy the wage threshold. The employer is required to provide that information. So this is with employees where, all of the proprietary interests that are recognized at common law are still recognized by the bill. And the obligation where those interests are present is to impose a limit on duration and scope and require advance notice and an opportunity to review and understand. That's exactly what the bill tries to address.
Thank you both so much for that. That has been my understanding, and information has come to me and in some conversations that I've had. So I appreciate being able to put that on the record through folks who have lived experience and are experts in this area. Before I move on, I do see Senator Kushner has raised her hand, but once again, I will just thank Mr. Goldblatt and Mr. Goodbaum for your patience. We are getting ready to wrap this up. Senator Kushner, you have the floor.
I'll be very brief, but I do want to, again, repeat how informative this has been, and I hope that you will be available to us to reinforce some of the important information that you've given us today, because I think this is a really important measure that Connecticut needs to move forward with. And I think one of the things that you touched on that I've heard from a lot of my colleagues is a misunderstanding about what is proprietary information and what is experience-based information. So for instance, knowing after learning on the job, which are the best suppliers and the resources, that's really experience-based information that's open to the public, as opposed to, real proprietary information. I think that point it helps me to have this discussion with my colleagues to understand that better. So thank you both.
Thank you, Senator Kushner. And thank you all. Thank you all, Mr. Holland, Ms. Gerstein, Ms. Arnold-Richmond. We really do appreciate you making the time to inform this committee and the public of the importance of this piece of legislation. And we do look forward to some sidebar conversations with you all moving forward. And with that, as I've stated, we have surpassed the 1 hour limit for elected officials and administrators. So I'm going to call up next Joshua Goodbaum, and then I will go back to the list, and Mr. Goldblatt, you will be after him. Mr. Goodbaum, you have the floor, sir.
Thank you, Representative Porter. I'm pleased to be with the committee, and I'm particularly proud today to be a constituent of Representative Porter's in New Haven, where I live.
Yes.
I submitted detailed testimony written testimony to this committee, as I did for a couple of bills that were under consideration in the last session. I want to say, in addition to what I put in my written remarks, that my passion for this issue is not financially motivated. I am a lawyer who represents employees. It is in my financial interest that non-competes be litigated as much as possible. It's not the only way I earn a living, but it is one way I earn a living. My passion for reform in this area has to do with counseling just far too many people at all levels of the income spectrum about their rights, and in particular, how my inability to give them accurate advice about their rights. As the Connecticut Law Tribune explained in an editorial it published last year, the nature of non-compete litigation makes non-competes relatively unsusceptible to common law development. And as a result, any given non-compete, it's very difficult to tell someone before litigation whether a court is likely to enforce it or not. The goal of this bill is not just to make the situation better for workers, but also to add certainty to the situation so that there can be more predictability, both for employees and for employers, so they can figure out what are they allowed to do, what are they not allowed to do. And I think that's a really important goal of any non-compete reform. There are many different ways that this bill could be written. I think this is a great but not perfect bill. If I were writing it, I'd make it retroactive to help the many tens of thousands or hundreds of thousands of employees who already have non-competes that would not be affected by this bill. But I think any progress is better than nothing. And I am available to the members of the committee to answer any questions you have based on my experience counseling employees, both now during this hearing window and also by email or phone. Any information I can provide, I'd be very happy to do so.
Thank you for your testimony, Mr. Goodbaum. And I'm honored to be your representative. You brought up a really great point, the predictability, and I think this goes a long way, and it actually runs congruent with several bills that we have on our agenda for this session. It really is about predictability and honoring, and giving dignity to workers and their ability to move forward and to move up, and to have a lifestyle that I think we all should have an opportunity to acquire. So
I can't tell you the number of people, Representative Porter, who come to me and say, I know I've got a non-compete. I don't want to violate it. I've got this job offer. Can I take this job? And I say, I'm not sure. I'm a pretty good lawyer. I've been honored by a variety of organizations. I'm very well educated. I'm respected in my field. And I can read these agreements, and they are generally so ambiguously drafted that it is very difficult to provide that advice. And then the consequences for breach are extreme, because almost every agreement says, if you violate this agreement, you've got to pay the employer's fees and costs. But if we lose in litigation, no harm to us. And most people, most normal people cannot afford to spend tens of thousands of dollars figuring out whether their non-compete is enforceable or not. So this extends not just to executives or high-level professionals who I counsel, but also to hairdressers and mechanics and exterminators, all people I've counseled about non-competes, all of whom I was not able to give accurate advice because the case law is not well established enough, but also people whose non-competes, at least some of the time, are governed by law other than the law of the state of Connecticut. I counseled an auto body worker a number of years ago who had worked in Connecticut his whole career, but the company he worked for, a national company, was based in Missouri. He'd never been to Missouri, but the non-compete was governed by the law of the state of Missouri. And if he got sued for violating that non-compete, he would need to answer for it in the state of Missouri, a place he'd never been. That strikes me as fundamentally unfair. It makes it really difficult for me to give him advice because I don't even know if the right person to give advice is me or a lawyer in Missouri. So just the simple advent of saying in this bill, Connecticut employees deserve to be governed by Connecticut law and to litigate their non-competes in a Connecticut forum is a very important innovation.
Thank you so much. You've made some very poignant points and some very interesting suggestions as well. So I do look forward to having a sidebar conversation with you. And I would hope that before you exit the public hearing, one of the clerks or admins will be able to acquire your information so that we can have contact moving forward.
Thank you, ma'am. I appreciate your time.
You're welcome. We appreciate your time as well. Seeing no hands for further questions, we thank you again for your time today. Up next, we have Mr. Goldblatt, and I would just say once again, thank you so much for your patience, and you have the floor, sir.
Thank you. Committee chairs, Senator Kushner, Representative Porter, members of the Labor and Public Employees Committee. My name is Mitch Goldblatt. I'm the Director of Human Resources for the town of Guilford, a selectman in the town of Orange, a member of the Executive Board of the Connecticut Public Employer Labor Relations Association, and serve on the Connecticut Conference of Municipalities Policy Committee on Labor Relations. Pension plans in the public sector are a dying breed, and not because pensions are a bad idea, but simply because they have become unaffordable and unsustainable. Unfortunately, enactment of Senate Bill 212, an act concerning permanent partial disability benefits and pension offsets, will hasten the demise of pensions in municipal government by putting even more stress on local finances. Employees earn their pensions based on a combination of factors, including salary, longevity, and a multiplier, most often the result of collective bargaining. When municipal pensions can indeed be high for those that earn them, it is hard to explain and justify the instances when someone earns more in retirement than they do as an employee. This bill would make that commonplace. Why is that? A typical municipal pension plan will pay an employee 50% of their base salary in a lifetime pension when they retire based on a disability. As long as the same individual is injured on the job, the workers' compensation benefit is typically 75% of their base salary. Due to the fact that this combination of pension distribution plus workers' compensation will easily exceed 100% of the retiree's salary, negotiated pension plans have wisely put a cap or offset in these situations. Also, at a time when municipal budgets are stretched, why wouldn't this sensible offset be maintained in what is already a well-established program? Finally, let's not forget that it is the municipal budget, often voted on in referendum by the residents and taxpayers. The costs for both the pension distribution and workers' compensation insurance come from the same pockets. There is no reason for the state to override the home rule and collective bargaining that have led to a system that has been fair and has worked for decades. Labor relations is about communications between the municipality and the respective labor unions. However, Senate Bill 212 implies that we are incapable of communicating effectively and poses unnecessary, unfunded burdens on Connecticut's towns and cities. I, along with the Connecticut Public Employer Labor Relations Association Executive Committee, as well as the Connecticut Conference of Municipalities, strongly urge you to vote no on Senate Bill 212. Thank you, and I'm here to answer any questions you might have.
Thank you, Mr. Goldblatt, and I do not see any hands raised. So again, I thank you for your patience and for making the time to testify today.
Thank you, Representative Porter.
You're welcome. You have a good day.
You too.
Thank you. Okay, and we're gonna go back to the public. And up next, we have Spillane Phillip, who's an attorney, Hokingan, Machado, and Lyon. You have the floor.
Good morning. My name is Philip Spillane. I'm an attorney representing injured workers in the workers' compensation system. I'm here today to speak in favor of raised bill number 222, which is an act requiring notice of discontinuing prescription medication under a workers' compensation claim. This act will essentially amend section 31-294D of the Workers' Comp Act by requiring advance notice of discontinuance of medication by an insurance company. It also provides the claimant with an opportunity to object and have a hearing. It prevents the insurance company from discontinuing medication without a judge's approval at a hearing, and provides penalties for violation. I'm here to tell you that this act is needed. This bill is needed because there is a lot of abuse in the system that requires it. I'm going to give you one example from my practice, which really establishes why this is needed. I represent a claimant who was in a chronic pain situation. He'd been on temporary total disability for years and narcotic pain medication for years. And unfortunately, as many people experience, he became dependent on those medications. We had ongoing problems in his case with the claims adjuster simply not authorizing his medications on a timely basis. He would go to his doctor, get his prescription renewed, and then go to the pharmacy and find that it had not been renewed, and he'd have to call me and we'd have to get involved. This usually got resolved with a few phone calls, but last summer it came to a head when he went literally 5 days without his pain medication. The adjuster was not available to anyone, myself, their attorney's office. After 3 days of no response whatsoever, I filed a bad faith letter with Chairman Morelli and requested an investigation into their handling of this case. As a result, Chairman Morelli got involved, and 2 days later we got a call that his prescriptions had been authorized and the adjuster was taken off the case. That solved the problem for that client in that instance. But I can tell you that in my practice, I've seen this happen many, many times, and I'm sure it's happening all over the state. We do need in this state some controls on the insurance industry, because when people's pain medication is discontinued, it can be catastrophic, and my client suffered for 5 days unnecessarily because there was no law in place to govern this situation. So I do speak in favor of the bill, and I urge that it be passed. Thank you, and I'm available for any questions you might have.
Thank you for your testimony, and I think you summed it up quite well. We do have this bill before us because of all the things that you just testified to, and I don't see any hands raised, so I will go ahead and thank you for making the time to be with us today and for sharing your experience as an attorney in dealing with these claimants.
Thank you.
You're welcome. Okay, so we will go back, and up next we will call Mr. Ken Tucker, Connecticut Department of Labor, Con-OSHA Director. You have the floor.
Good morning, Senator Kushner, Representative Porter, Senator Sampson, Representative Aurora, and the members of the Labor and Public Employees Committee. Thank you for the opportunity to provide you with testimony regarding House Bill 5247, an act concerning volunteer fire departments and ambulance companies, and a definition of employer under the State Occupational Safety and Health Act. My name is Ken Tucker. I am the Con-OSHA Director for the Connecticut Department of Labor. The Connecticut Department of Labor and Con-OSHA supports this proposed bill. This bill is necessary to ensure that our volunteers within Connecticut's fire departments and ambulance companies can perform their duties in the safest and healthiest possible manner. This bill would amend the definition of employer within the Connecticut Occupational Safety and Health Act to include volunteer fire departments and ambulance companies. The U.S. Department of Labor, federal OSHA, has determined that they do not have jurisdiction over these volunteers because of the close affiliation within the municipalities that they serve. Federal OSHA's jurisdiction is limited to private sector entities only. Because of a Connecticut Supreme Court ruling in 2011, certain volunteer fire departments are not held accountable under the Con-OSHA Act to protect the safety and health of these volunteers that serve their communities. This means that certain departments are not held accountable for the safety and health of their volunteers under state law or under federal law, and this is unacceptable. The hazards involved in firefighting are inherent. Volunteer fire departments and ambulance companies must be held accountable to ensure that the safety and health of their volunteers are not jeopardized. The safety and health of all individuals, whether they work in a career department or in a volunteer capacity, must be maintained. All of our first responders, not to mention the municipalities that they serve and their families, deserve to have the protections afforded to them under the Connecticut Occupational Safety and Health Act. If this proposed bill prevents one injury, one illness, or God forbid, one fatality, then we have succeeded in our mission to ensure that workers stay safe and healthy and return home at the end of their duties the same way that they have arrived. Thank you for the opportunity to provide this testimony. I'm available to answer any questions you may have.
Thank you, Director Tucker. Senator Kushner, you have the floor, madam.
Thank you, Madam Chair. I know we have had this bill before us in past years, and unfortunately, we've not been able to get it through to the end line. I think one of the things that recently occurred with the leadership of the Labor and Public Employees Committee is that we were involved in the task force on cancer relief. And what was interesting to me about that conversation and the work of that task force is that it was really clear that we have a large force of volunteer firefighters in the state. We do not realize that it's substantially larger than the career firefighters that are employed by our towns and cities. I guess my question to you is, you mentioned very specifically affect certain volunteer departments, and if you could just briefly explain to us, I believe some are already covered and some are not. Is that the case?
Well, that's our belief after researching the Supreme Court ruling. That particular ruling specifically ended up being ruled that we didn't have jurisdiction over that department based on some specific parameters that we had looked at, whether it be how much money that the town provides that particular volunteer fire department, who maintains their vehicles, who provides their protective equipment, workers' comp, utilities, etc. We have a litmus test that we try to use for all departments. It's not perfect. There's not a specific answer to say that if you answer 5 yeses to one of the questions, is that part of it or not? We look at whether or not the allegations that's provided in a complaint, for example, will be a detriment to the volunteers that work in these departments. And we are trying to protect the safety and health. So there are some that are very similar to the Supreme Court ruling, and we have made a very clear decision that we are not going to do any inspections there because of that ruling. But there are some that are much more aligned to community support through mainly finances. And for those, we have made an attempt to do inspections in the appropriate times that we get complaints or we have accidents in their workplace.
Thank you for trying to answer that. And now I see the complexity of it, why it wasn't an easy question to answer. I do think that I am convinced that we need to protect all of our volunteer firefighters and make sure that we are doing the most to ensure their safety on the job. We owe them a great deal because they serve our communities, as a volunteer, which is exceptional work. And so I appreciate you're bringing this forward again this year, and hopefully we can get it passed. Thank you.
Thank you for your support.
Thank you, Senator Kushner. I absolutely concur. There's something really admirable about people that will volunteer to do work that would and could cost them their lives, or we have a cancer study, right? That could put them in positions where their health is really compromised. to the point of death. So we are certainly looking to make sure that we're doing everything we can to give them what they need. So thank you again for making the time to be here in support of this bill.
Thank you.
You're welcome. You have a great day. All right, up next, we have, who do we have up next? We will go back
we'll
and we will
just-
ask Daryl Duscinski,
Just
the
wait
Connecticut
one
Department of Labor
moment for
Deputy
the
Commissioner.
next member of the public.
Thank you, Chairperson, Representative Porter.
Senator, excuse me, I'm sorry, Daryl, but I don't think Representative Porter that you could hear our clerk interrupt. We have the obligation to alternate with the public. And so I believe we have to put a pause on you. I just started, but we do want to respect the public. So I think the next speaker.
I am so sorry. That is correct. I am sorry.
Yes,
I
I'm
am
sorry.
supposed to be rotating, so please pardon me on that error. Up next, we have Aleska, and I hope I'm saying this right, Benista, Glorious Recovery Foundation founder and CEO. You have the floor, madam.
I don't think she's joining as a panelist right now, but we have number 11, Roberto Fernandez.
All right, so up next we have Mr. Fernandez, 32BJ SEIU Political Director. You have the floor, Mr. Fernandez.
Hi, this is Frank Stoltz. I'm with 32BJ and the Communications Department. Bob had an emergency medical appointment, and we were also hoping that Milagros Vasquez would be testifying. I'd like to ask the committee for a moment of indulgence. I could read Milagros' testimony on the recall bill extension, but if that isn't permitted, we could just submit it in written form.
Mr. Fernandez, that would be fine if you wanted to read her testimony into the record.
Okay, thank you.
You're welcome.
Thank you to the committee for hearing my testimony in support of House Bill number 5246 to extend the rights of certain workers to be recalled after pandemic layoffs. My name is Milagros Vasquez. I'm one of the workers whose case I'm told helped make the law I hope you will extend. The law stops bosses from using pandemic layoffs as a way to replace experienced workers with new ones. Sometimes a boss might want to use a pandemic layoff as an excuse to hire new and inexperienced workers because they're cheaper or because they're easier to intimidate. In my situation, my boss hired workers after laying off my coworkers and me because he wanted to do something that was against the law. He wanted to stop us from organizing for better conditions and a union at the service plazas. For 13 years, I worked at the McDonald's at the I-95 Plaza near Darien. The plazas are all on state property, and the owners of McDonald's and Subway and Dunkin' Donuts and all the other fast food companies, they contract with the state to run their businesses there. That means by state law, they have to pay the standard wage. But for 13 years, I only made the minimum wage. My pay went up only when the minimum wage went up. I was never told I had sick days, and for years I worked without any vacation time. The situation, I believe, was the same at many other Service Plaza fast food restaurants too. That's why my coworkers and I began to speak out for better conditions and a union with 32BJ SEIU in 2019. My boss, George Mitchell, didn't like that, and when the pandemic arrived at the end of March 2020, he used the pandemic like a weapon. We were among the first workers laid off at Mitchell's restaurant, and weeks later, we discovered new workers were being hired to replace us. The union took my case and those of 3 coworkers to the National Labor Relations Board. We also spoke to the legislature, and thankfully, you passed the current law to protect service workers suffering unfair layoffs. We used the new law to sue our boss, but before that case went very far in the Connecticut court system, we won at the National Labor Relations Board, and the administrative law judge ordered George Mitchell to give us back our jobs. This week, I started work again. It was frightening, but I know the workers look to us to stand strong. Thanks to our fight, the wages have improved, and now we must continue fighting until we win a union. We're able to return to work because we have the support of so many people, my coworkers, other Service Plaza workers, the union, and many legislators like you who have stood with us for the last 2 years. We hope the governor and his agencies will do more to improve the situation on state property, but I'm here now to thank you for all you've done for us and to ask you please to extend the law. The pandemic didn't end as we thought it would when the law was passed last summer. Now we know that we cannot take the future for granted. I think we need the law for another year at least to protect workers against future abuse, and so workers will have more time to learn about and use the law if they need it. I hope the committee will vote in favor of Bill 5246 and help us pass it into the legislature so bosses will know they cannot use a public health crisis to take advantage of service workers like me anymore. Thank you.
I was muted. Thank you, Mr. Fernandez, for reading Milagros' testimony. We certainly did have the opportunity to be out there with them. She was a catalyst for this bill. And we thank her and the many other workers for having the courage to stand up and to stand strong. Leaders, by all means and all definitions. I do see that Senator Kushner has her hand up, so I will recognize her, and you have the floor.
Thank you, Madam Chair. And I just wanted to, I have a couple of questions for you. Even though you are not Milagros, I think you're very, very familiar with the situation. So I would like to get a few of my questions into the record. And but before I start, I hope you will extend our congratulations to Milagros. If there was ever a good reason for someone not to be available to testify, it would be that she returned to work after a long struggle and a long period of time. So we wish her well, and we applaud her courage, as my co-chair said, in taking up this issue and returning to work. I think it's incredibly important. So, but I do want to ask you some questions because we had some testimony earlier today, questions from regarding this recall rights bill, and I want to make sure that we're clear in the record. This bill, as it was passed last year, only pertained to certain industries. It was suggested that, and one of those industries, as you pointed out, is the fast food service worker in the plazas, the interstate highway system plazas. It would also apply to other fast food workers. And so one of the concerns was that by requiring an employer to rehire a worker who was laid off because of COVID, that somehow that requiring that rehire would impact and depress job creation and jobs, the availability of jobs in the state. I wondered if you could address that.
I don't see how that would be the case. I think, if anything, speaking about the workers at the service plazas, when Milagros first returned to work, which was just on Monday night, she and the other workers were greeted by her co-workers and all the workers at the service plaza with a lot of congratulations and joy. So I know that it's a great boost to morale to know that they weren't unfairly let go and that their jobs were protected. And I think the message that other workers would receive and that potential employees would receive is that a law like this protects them and they won't be able to be so easily replaced. I think it makes the jobs more attractive in the end to new hires, as well as to people who've been there a long time.
And I know that there are limitations. There were limitations on the amount of time that this law was in effect. It would sunset in May of this year. And as Milagros testified that she was interested in seeing extended another year because we are not through with the pandemic yet. So we could see, I think that applies to both. There could be another spike where we see layoffs again, but more importantly, I think some of it applies to the fact that we're not back to full employment yet in many of the businesses that are covered here. So I know that was the reason for the extension. In Milagros' testimony, she says that she was working there for 13 years, which is, a lengthy period of time. So is your understanding that this law would require them to bring back a long service worker like Milagros prior to hiring a new worker?
Yes, that's right. So that their jobs would be guaranteed, that they would be offered the job. So it's not like there's any job lost, that job would go to the person who had it before. And so it's either a new worker would get it who had no experience at the job and maybe was being paid less as well in certain circumstances, but also the other person who didn't have the job would still be out of work. So what this does is just it guarantees a certain fairness. The decision by the NLRB was almost 50 pages long, and it was just repeatedly damning as to McDonald's reasoning for not calling back these 4 workers, saying that they were, all the evidence showed that they were targeted specifically to prevent workers from trying to speak up for better conditions at the job. And like she said, for 13 years, she never knew, she was never told that she could take a sick day. So when workers took sick days, they just lost pay. They just assumed that those hours were lost. And vacation time was something they were denied for years. She was denied for years. So they had plenty of reasons to be speaking up, but they also had plenty of expertise, and they speak and have spoken before about how much pride they take in their ability to do their jobs really well and efficiently, and do everything that's required of them and be there always when they're asked to be, which you never know with new workers whether you're going to get that or not.
Thank you. And thank you for standing up for these workers. 32 BJ has been with them from the beginning, and a lot of people wouldn't have a resource like that. So we really appreciate it. And you know, I do want to acknowledge not only was Milagros and the other workers there, they were certainly the stimulus for this bill coming forward, but specifically Representative Porter and I were attending a rally when we were outraged that we heard that they had been laid off and not been brought back and new workers were coming in. And we were speaking about that publicly, and it was picked up on by a journalist who actually put us in touch with people in the state of California who were concerned about the same issue. And it really led to the development of the bill that was passed last year. So please, again, extend our congratulations to Milagros, and we want to extend our congratulations to 32 BJ for taking up this fight. Thank you, Madam Chair.
Thank you, Senator Kushner. Yes, you may, Mr. Fernandez.
Thank you, Senator Kushner. Thank you, Judge Porter, for everything. The union also thanks you for standing up for them, and to other members of the committee and other members of the legislature that have done so much to help these service plaza workers who are just trying to be treated decently. Thanks again.
You're welcome. At this time, I will recognize Representative Aurora. You have the floor, sir.
Oh, thank you, Madam Chair. And thank you, Mr. Fernandez, for your testimony, and also for your good work in making sure that no worker in our state is basically taken advantage of. Because, you know, you may sometimes see me talk about in this committee about making sure that businesses do not have onerous regulation. But, you know, I want to make clear that that the idea that a business, there are businesses out there who may take advantage, and that's not okay. It's not that when we say businesses should have ability to create jobs, that they have the ability to exploit even one worker out there. And the work you do to make sure that that does not happen has to be commended, has to be appreciated, because that's the only way we can ensure equity in terms of working conditions, in terms of fair relationship between a worker and an employer, and so on. So I thank you. I congratulate you. And what I want to ask you is basically more focused on very much confined of this law. Please do not take it along you know, other good stuff good work that you do. My question really is that, would you agree that in this situation, which really you were mentioning and discussing, and the Ms. Milagros situation, that employer was being unreasonable and really not following the law, existing law?
That's true, Representative Aurora. And first, I would like to say I appreciate, and I'm sure the union and the workers also appreciate your voice of support for speaking against abusive employers and in support of workers who are trying to make their conditions better at their jobs. But I would add that they did start the process of trying to get redress from this law because they didn't know whether or not their case would get much traction at the NLRB. There have been points in history when it's been very, very difficult for workers to make this kind of case. This happened to be a really egregious instance in which it was able to be shown that there was a violation of the law. And on top of that, they also had the backing of us, of the union, to go to bat for them at the NLRB, whereas the law protects individual workers who might not have any union or any other worker organization standing up for them. So they would have the ability to do individual redress and enter into a suit against their employer.
No, thank you. No, that's I fully agree, and you always have our support when you are going against abusive employers. No one has a right. That's, I take that seriously as the role of the government to make sure there is no abusive employer ever in the state of Connecticut. You will always have our support, and whether there is no partisanship here in that element, that if somebody is breaking the law, somebody is abusing or creating conditions which are untenable, please come to us as a committee, as individuals, as members of this legislative assembly. You always will have the support. Now, the question which really narrowly we want to focus on is really now that, for most part, we are seeing a very tight labor market, right? Most of the concerns which we are hearing from businesses are they would love to expand, and in many different businesses, whether it be construction, whether it be, even retail, that's happening as well, that they can find cooks, they can find this, they can find specific trades. And also that the nature of the business has really changed. It is more takeout, it's more, outside, there's a lot of changes going on, and some necessitate some degree of that. You do not want to, you may have had 4 people waiting earlier. You need, 2 more packaging now, which to some extent would mean that, maybe you pay more to a waiter or less to it. It may go both ways. So that's one of the concerns, and I would love to have your thoughts on it, because we're not saying, or nobody's saying that we should allow abusive practices. We're saying is this recall restriction going forward will limit some of the business's ability to hire the right people needed for the specific roles they have as they grow the business, and that there is a significant opportunity for workers because of the shortage. The power has tilted from in terms of, because it's a tight market. So that's, perhaps if you could, give us your thoughts on it. And it's an honest interchange or candid interchange of ideas here. I understand that most times unions would like to, focus on making sure, the rights in the of any, but there is a give and take in some sense. We want to make sure we give business a flexibility to hire the right kind of people, the right kind of folks, not exploiting them, but making sure that they have the right employees for the work going forward, not going backwards, how people were hired 2 years ago. And secondly, the market is doing a pretty good job of making sure nobody takes advantage of anyone, because as I hear, everybody is in great demand. So this may be the wrong time for a legislation like this. Your thoughts and your input would be really appreciated.
Well, I think the case speaks to the fact that workers were found to replace these workers. So though the labor market there's no question that employers have said they've had difficulty finding workers, but I don't know if that means they're so constrained that they couldn't find the right people for the right job. This is a law that would protect workers' rights to get recalled so that they're not abused or exploited. It doesn't change an employer's ability to make certain demands or to find the right people for the right job. I just think it would mean that you wouldn't be able to use the pandemic as an excuse to then get rid of some employees and then call up new ones. If your situation has changed, I think that your old employees would have the right to see if they could fit that new job. I think employers have a lot of leeway to change workers if there's any need beyond the specific needs of giving employees the right to return to the jobs that they held once the pandemic emergencies has gone down.
Thank you, Mr. Stoltz. That's all I had. I'll yield back. I appreciate once again your time and your replies, and I'll give it back to Madam Chair.
Thank you. Thank you, Mr. Saltz.
Thank you to all of you for the
Gonna get your name right. Kept calling you Bob. And we know you're not Bob. All right, Senator Kushner for the second time.
I apologize for coming back, but there was something just raised that drew my interest because I've heard this come from other criticisms of this particular law. Concern, I should say, that perhaps it wouldn't be the same job that the person was coming back to fill. And that did come up last year as we addressed it. And I think that that concern was actually led to inclusion in the bill of provision that the person who is recalled, if they're coming back to a different position, then they would have to be able to be trained in the same amount of time that it would have taken to train a new employee. So I do think McDonald's is a good example, or a janitorial service, or a takeout restaurant. Let's remember, we really are only talking about janitorial jobs, hospitality jobs, and food service jobs. And so, we're talking about three very specific industries. But let's take the example that was given before, and I know you've done a lot of work with these folks, so you probably have some idea whether this kind of training would be adequate. So if you have somebody at a McDonald's who was working the counter, for instance, I would assume they are often cross-trained, but in the event that they hadn't been cross-trained, do you think that a person who had worked in a McDonald's for 13 years would be able to come back into a different specific position, but would be able to be trained rather quickly to fulfill any new job requirements?
I think so. In fact, if Milagros were here, I think she'd testify very specifically to that. I know that she was asked to do certain new tasks and given instructions, and she said, yeah, it was a breeze. This is stuff I know how to just adapt to it because I've done something very similar for so long. So in these positions specifically, I appreciate Rep. Aurora's concerns, but in these positions that the law covers, I don't think that that's an issue at all.
Thank you so much. And thank you, Madam Chair, for allowing me to clear the record on that issue. I think it's come up before, and I think it's important to have testimony from people who are very close to the work. So thank you very much.
Thank you again.
You are muted, my dear friend, Madam Chair.
Looks like I'm gonna have to get myself a t-shirt now. Just wanted to thank you for bringing that up, Senator Kushner. I always say people closest to the problems are closest to the solutions. And I believe that is why public input is so important when we are putting forth legislation that may become law. So please thank Milagros again, her and her team. Teamwork makes the dream work. It was a group of workers that came out courageously. So please be sure to give them our congratulations, especially to Milagros returning to work, especially now, big deal. So thank you again and have a great day, Mr. Saltz.
Thank you so much to the committee for hearing our Milagros testimony.
You're welcome. Thank you. All right, up next, we will go back. Mr. Dzinski, Connecticut Department of Labor Deputy Commissioner, you are up for real now.
Great. Thank you, and good afternoon, Madam Chair and Representative Porter, Senator Kushner, Senator Sampson, Representative Aurora, and members of the Labor and Public Employees Committee. On behalf of Commissioner Bartolomeo, I want to thank you for the opportunity to provide testimony regarding Senate Bill 210, an act concerning technical and other changes to the Labor Department statutes. Also, I am available to provide information on Senate Bill 210, House Bill 5245, and House Bill 5249. My name is Daryl Dazinski, and I am the Deputy Commissioner of the Connecticut Department of Labor. Senate Bill 210, an act concerning technical and other changes to the Labor Department statutes. The agency supports this bill and provides technical revisions to the Department of Labor statutes. There's several amendments to the Public Act 21200, the act restructuring unemployment insurance benefits and improving fund solvency, that are required in order to bring the act into conformity with federal law. It extends the use of factors that will be reducing each employer's charged unemployment rate for calendar years 2026 and 2027, which is similar to the language used for those calendar year reductions in 2024 and 2025. There's a Scrivener error in that should be fixed, replacing the percentage for calendar year 2026 from 1.123% to 1.125%. There's a need to correct the date that all amendments begin, although this is unclear in one section, so I'm correcting that, as the intent is supposed to be January 1, 2024. The provision that provides that the claimant's benefit rate cannot be lower than the prior year also must be amended. In two examples, if the claimant qualifies for a new benefit rate but has lower wages in their base period, the rate must be calculated at the reduced rate by law. And the second one is the annual review of the maximum benefit rate, which at times can be lowered as well. So those are the two provisions in which, under federal and state law, we must reduce the rate based on the previous year rate. In addition, looking to amend the reporting requirements in the Step Up and the Veteran Step Up programs in order to streamline the legislative submission process, requiring annual reports only for years when the program operates, requiring that the reports be completed and submitted on a fiscal basis and be based on data for the most recent fiscal year. The bill would allow for electronic publication of the Unemployment Compensation Act and any regulations, annual reports, and related materials. And additionally, makes general neutral references to positions in the Unemployment Compensation Act within the Employment Security Appeals Division. The act would repeal various obsolete statutes and subsections, including the establishment of a self-employment assistance program, as the program does not exist and would be out of conformity with federal unemployment compensation law. The requirement to collect population and employment data, which the agency already delivers and provides in a more detailed and timely manner through the Office of Research. And the statute referencing a Department of Factory inspection, as it no longer exists under the management of the Labor Commissioner. Also asking that rather than amending CGS 31-40A to remove references to the Department of Factory inspection as it currently is drafted in section 16 of SB 210 and should be repealed in its entirety along with CGS 31-9. I want to thank you for this opportunity to provide this testimony, and I'm available to answer any questions you may have.
Thank you, Mr. Dazinski. I don't see any raised hands, but I do know that you mentioned two other bills, 5245 and 5249. And if you wanted to weigh in on that, you could take this time to do so, and then I will recognize Representative Aurora.
Great, thank you, Madam Chair. There was actually three. So Senate Bill 211 is an act concerning a return to work program. And the agency has several concerns with this act. The study would be unnecessary and duplicative. It requires the Department of Labor to study the benefits, implications, and feasibility of creating a return to work in the state, and whether the state's step-up program is equivalent to comparable return to work programs. The agency, the Department of Labor, already provides many return to work programs, such as on-the-job training, subsidized worker experience, transitional employment, registered apprenticeship programs, youth employment programs, second chance initiative, and the platform to employment and opportunities for long-term unemployed individuals. House Bill 5245, an act concerning forced arbitration agreements and allowing certain court actions to be brought on behalf of the state. There's concerns about Section 2. The intent is well-meaning. However, the requirement that the agency distributes various grants collected in a non-lapsing general fund, community outreach, and workplace account would place an undue burden on the Department of Labor. We do not have the staff to fulfill this mandate. It also requires that the agency distribute 25% of the civil penalties collected to labor or nonprofit organizations to fund outreach, education, and technical assistance pertaining to employee rights in the workplace. When considering applications for such grants, the agency must give priority to projects that provide services to especially vulnerable workers. Grant writing specialists would be needed to draft the request for proposal and staff to manage this new grant program, which would require the agency to hire, again, additional staff. House Bill 5249, an act concerning the non-compete agreement. The agency supports this bill, but reminds that there's no ability to enforce. Thank you, Madam Chair.
You're very welcome. I'm going to go back to 5245, Section 2, the concerns you had that you said undue burden. Outside of Section 2, is the rest of the bill good? Are you in support of? Is this the only issue you have with the bill?
Our concerns are with Section 2, Madam Chair.
All right, thank you for that clarity. Representative Aurora, you have the floor.
Thank you, Madam Chair, and thank you, Deputy Commissioner Dudzinski, for your testimony. I really appreciate all the work you do. I just wanted to thank you for providing the insights. We'll definitely be looking into the points you raised. I hope we're not weighing more on you. I know you have a big technology release going on and a lot of good stuff. And we are rooting for you because we are hearing a lot from our constituents that those things are quite necessary and overdue. And so we also want to make sure that we don't put undue burden from new regulations. So we really do appreciate your thoughts, your insights, and your comments on these legislation. And as you know, if there's anything more we can do, please do provide us the feedback so that we can kind of include that in all our discussions. That's all a comment I had. And back to you, Madam Chair. Thank you, sir, again. And if you'd like to make a comment, please feel free. Otherwise, I'm good.
We appreciate you, Representative Aurora. Thank you.
Thank you. Seeing no further raised hands, I will go ahead and thank you for taking the time today to be with us, Mr. Dudzinski, and for bringing those concerns to our attention. And we do thank you for your support on the bills that you are supporting.
Great, thank you. Good day.
You as well, thank you. Okay, so up next we will have, and I do believe I see her in the room, Alex.
We may have lost Representative Porter for a moment. So let's give her a minute and see if we get her back. it may have been a technological problem on her end. Give me a second.
I think she called my name Alexa Bempnista, so I'm here.
She did, and I see you there, but I also know she dropped off the screen. So let me just check. I know Representative Porter has another hearing that she has to step into for a moment. So I am here and ready to chair. And I would suggest if she comes back, we'll have her take over the chair. But in the meantime, I do see you and recognize you, Alexa Bempnista. Is that how you say your last name?
Bempnista, yep. Mm-hmm.
Thank you so much. And you could go ahead and proceed.
Thank you so much. So my name is Alexandra Bempnista. Everybody calls me Alexa, just like the Amazon Alexa. And I'm here to testify on the bill HB 5248, which is about employer discrimination against individuals with criminal record. I am a highly educated, intelligent, professional woman with a long-standing career. And I have masters from NYU. And I am testifying here because I'm also a person in long-term recovery, which to me means that I have been alcohol and drug-free for almost 7 years. In 2011, I was put in a position where I was interviewing for a job, and I was offered a position with an official offer letter from an employer. And then once the background check was completed, unfortunately, the employer withdrew the offer because of my criminal record, which is a misdemeanor. I'm gladly to report that currently I have a wonderful job at a large corporation, and which is a federal contractor, very prominent here in Connecticut. And because they do not, discriminate against the misdemeanors. Although during that time when I was struggling with substance use disorder, I was facing 3 felonies for my DUIs. And thankfully, a very compassionate judge has dropped the felonies and has worked with me on, treatment plan. And I had, landed with just misdemeanors, and my current employer did not discriminate against, has no policies against hiring individuals with misdemeanors. So I have a wonderful career. I am, as I mentioned, a person in long-term recovery now over almost 7 years, wonderful mom with 3 teenage children. And so I would like to, testify on behalf of this bill, because there's still many employers that unfortunately do discriminate because of the substance use disorder criminal records individuals. And just because I'm struggling with this mental illness, I needed to be helped, not punished. And just because I have this mental illness, I'm currently in recovery, that does not disqualify me from the particular jobs that, I have applied and I was denied for because of my criminal record. So I would like to just, raise awareness that even ONDCP with President Biden has put, a priority last year to really work with employers to remove the discrimination against people in recovery from substance use disorder. But it is clearly stated in the priority that a lot of employers are still reluctant. So I think that there would be really, it necessitates to put some kind of legislature and law to make sure that employers don't necessarily have a choice to hire or not hire. If an individual is qualified is in recovery and continues the recovery, they should not be not offered the positions that they were qualified because of the criminal record.
Thank you so much for your testimony here today, and congratulations on your success. And I appreciate, I always appreciate people who they themselves have found a pathway and have found a supportive employment situation, but still take the time out of your schedule to be here to advocate for others. So thank you so much. And I don't see any hands. So we will move on to our next speaker. So thank you, Alexa.
Thank you so much.
Great. Next up, I am looking to see if we have, I don't believe we have Naja Farley. Is Naja Farley here? I don't see him. So we will move to number 12, Jess Zaccagnino. Oh, you're going to have to say your last name for me. I'm sorry.
You got it pretty close. It's Zaccagnino. The G silent, it's tough. All right. Senator Kushner, Representative Porter, Ranking Members Sampson and Aurora, and distinguished members of the Labor and Public Employees Committee. My name is Jess Zaccagnino, and I am the Policy Counsel of the American Civil Liberties Union of Connecticut. I'm here to testify in support of House Bill 5248, an act concerning the collateral consequences of criminal convictions on occupational licenses, with some recommended amendments. The ACLU of Connecticut believes in a society where all people, including those who have been convicted or accused of a crime, have an equal opportunity to contribute to society and build successful and fulfilling lives. People involved in our criminal legal system who finish their sentences have paid their debt to society. Instead of enabling people with criminal records, Connecticut law makes it difficult for them. Of the over 550 barriers that are written into our state's law, the large majority are related to employment. This accumulation of collateral consequences can create a daily nightmare for people with records who are just trying to find work. Wages never recover for most people since incarceration is linked to significant decreases in annual earnings. The employment barriers faced by people with criminal records have only worsened during the pandemic. Racial disparities in Connecticut's criminal legal system are also replicated when people return home from incarceration. There is one way forward. One single employment anti-discrimination statute, section 46A-80, provides that the state, when acting as an employer, cannot preemptively ban all people with a criminal record from seeking a specific position. But rather, the state is required to start from a place of non-discrimination and may only bar a person on the basis of their criminal history if a very specific individualized assessment is conducted. That assessment asks the state to consider, first, the nature of the crime and its relationship to the job, second, the degree of rehabilitation, and third, the time elapsed since conviction or release. An employer is only justified in denying a person a job if the answers to this individualized assessment show a clear, particularized reason why the applicant's criminal record makes them a poor fit for this specific job. This is an excellent model for helping to break down barriers faced by people living with a criminal record. In its current form, House Bill 5248 fails to address the litany of collateral consequences related to employment and instead focuses its energy solely on licenses. Additionally, the ACLU of Connecticut recommends that this committee apply the individualized assessment that has already been successful in the valuation of candidates for state employment. This test requires a high degree of connection between the crime and the type of work, a substantial nexus, which offers more protection to people living with criminal record than the currently proposed reasonable relationship standard. The current evaluation is less thorough, taking a less individualized approach that makes it easier for discrimination to fester in Connecticut's job market. This committee would be well served by applying the existing and successful test under section 46A-80. All people in Connecticut have paid the price of mass incarceration, yet we cannot afford the cost. Let's work together to build stronger communities by eliminating barriers to employment for people living with a criminal record. The ACLU of Connecticut strongly urges you to pass House Bill 5248 with 2 critical amendments to match the individualized assessment existing to public employment practices and to expand the legislation to address discrimination in both employment and licensure. Thank you.
Thank you. And I know that the ACLU has been very involved on this issue, and I appreciate all the input. I hope that you will get us those amendments so we can take a look at them in writing. I'm sure we'll have an opportunity to continue that discussion, but appreciate your work and your testimony here today.
Definitely. I'll connect with your office offline. Thank you.
Thank you. And I don't see any hands at this time. So I will move on to the, before I move on to the next speaker, let me just make note for the public that are here and watching, and for all of you testifying in the committee. We have had a very serious technical problem, and Representative Porter was kicked off inadvertently. It wasn't that she left and she's having trouble getting back in. They're sending her links. We're trying to correct that problem. I feel particularly bad about this at this moment because Representative Porter has been one of the leaders in our state fighting for equal access to justice for all. And she has informed me greatly about the great work that you've done at the ACLU and Smart Justice Campaign. So it couldn't have happened at a worse moment, because I know this is something that she cares deeply about, and hopefully she'll be able to rejoin us. But let me assure you, I know she will look at the testimony that was provided here today, and that she will, you know, she applauds all of your work. So I'm speaking on her behalf now. So, but unfortunately, it's just sometimes these technology issues happen. So thank you all, and I will move next to a dear friend that I've seen often at the Capitol, Anderson Curtis. You are next up on the speaker's list. Go ahead.
Well, thank you. Thank you very much. My name is Anderson Curtis. I'm the Senior Policy Organizer at the American Civil Liberties Union of Connecticut, and I yield my time to Manny Sandoval.
Hello, Representative Porter and Aaron and Senator Kishner and Sampson and distinguished members of the Labor Committee. My name is Manuel Sandoval. I'm a resident of New Britain, Connecticut. I'm a smart justice leader, and I work as a clinician for a community mental health organization. I'm a parent, a husband, a homeowner, and I'm passionate about helping people. I'm here to testify in support of House Bill 5248 because for me, the collateral consequences of criminal conviction on occupational licensing has been strenuous, demoralizing, and at times outright cruel. Over the past 10 years, I've been diligent to better myself to be a model citizen. Of course, at times asking myself why. If society chooses to deny my progress is real, it continues to make difficult for us to drive with roadblocks like the bills discussed here today. Why? We can barely survive as it is, but who cares, right? We are just that discarded population that society can point their fingers at and say, yes, those are the bad ones, the ones who can't get it together. Of course, part of the reason we can't get it together is because society won't let us get it together. I continue daily to better myself. I became a peer support specialist in an attempt to obtain a job with the state. I was offered the position only to have it reneged upon once learning I had a criminal conviction. That was devastating for me. Luckily, months later, I was blessed with an employment opportunity with a nonprofit organization. Thank you, Compass Peace Builders. However, this was not enough. I decided I wanted to better myself by getting an education. I received my bachelor's degree in the Human Services from Springfield College, graduating summa cum laude, and becoming the class speaker, continuing my education. I earned my master's degree in social work from the University of St. Joseph's. However, I find it extremely interesting and detrimental that I have faced nothing but uphill battles due to my convictions. Our legal system says if you commit the crime, you must do the time. However, we all know that is far from the truth. Our legal system is one of oppression. Once you have completed your sentence, you're free to go. The problem is go where? If you live in public housing, that is no longer an option. Need employment? Most jobs discriminate against previously incarcerated people. If you're lucky to find employment, the pay is usually poor. If you happen to be one of the smart ones who decided education is essential, you bind yourself up in debt only to receive an education that will provide you with the bare minimum because the state of Connecticut will still deny you licensure. Why does the person criminal conviction after they have served their time make it ineligible for licensure? Have they not earned it through the dedication, hard work, sweat, and tears? The state should not deny the license of any person who has completed the educational requirements, has the experience and skill to do the job. The state should not deny me my social work license after all the work I've done. I'm a positive and productive member of my community. I've lost over $30,000 within the last 2 years. I've been battling the Department of Public Health, in which I requested time and again to be provided with an opportunity just to sit for the exam. I was denied multiple times until they finally let me sit, and of course I passed. However, I'm currently on probation with the DPH and provide documentations quarterly to be licensed. The problem with this convoluted system is that there appears to be no room for forgiveness. Maya Angelou said, "I did then what I knew how to do. Now that I know better, I do better." Senators, I did then as I knew then. And now that I know, I do better. I say to you, please do better. We shouldn't have to jump through hoops to be licensed when we have done the work. Thank you for your time and listening to my testimony.
Thank you. And I apologize, but if you could repeat your name clearly for the record.
My name is Manuel Sandoval.
Sandoval?
Yes.
Thank you, Manuel. Your testimony is so critical to our understanding, and it is exactly why we are taking up these issues today. We did have a council on collateral consequences for persons with a criminal record, and we learned in those meetings that there are a huge number of statutes in Connecticut that serve as barriers to housing and to employment, and it really goes against everything we believe in, and it really is not, it's not good for the whole state. And so, I think that your testimony here will help us correct some of these problems that have existed for a long time. So I do recognize our Vice Chair, Representative Manny Sanchez.
Thank you, Senator Kushner. Manny, always good seeing you, brother. How are you?
How you doing, Manny? Thank you.
Good. I just want to go on and say you've been a phenomenal community steward. You've gone above and beyond for so many. And I know you're here testifying on your personal story, but with the understanding of how many other people have gone through what you were experiencing. Can you speak to those barriers and struggles in attaining your license and how it has personally affected you, and what those setbacks have meant for you and your family?
Like one of the first ones I need to highlight is the fact that the monetary, right? We all live in a monetary world. And over the past 2 years, I was stuck at, a job where I was making under, let's say 35. And that's like, being nice about it, right? And the base pay for master social work is somewhere around 50, right? So you're looking at about $15,000 that I'm just, and I'm being gracious, right? Because in reality, it was less than that. But that $15,000 was essential for myself and for my family. Not only do I have bills like everybody else, I also have education, bills that were tacked on, right? And thank God for the pandemic, right? Because they put a little injunction there. But otherwise, I would have been having to pay that debt back for the education, right? And still had to make my daily needs, but that was not the issue. I've been making less than I should be because of the fact that I have not been able to get licensed. Well, I mean, I'm licensed now as a master social worker, but it took me like hoops after hoops. I had to communicate with Robert Sanchez helped me. He was able to communicate with someone from DPH, and they actually decided to give me a chance, and I'm on probation. I have to complete a whole bunch of documentations showing that I'm living up to the expectations of a licensed social worker, and that's right there is hard to do. I mean, it's not hard to do because I'm good at it, right? But we shouldn't have to jump through extra hoops when everybody else that passes the exam, they just go right in, they take the exam. You shouldn't have to wait to be approved to take exam.
Manny, thank you so much for your testimony, speaking on your behalf and the behalf of so many others. Senator Kushner, that's all I have. Thank you.
Thank you very much, Manny. I appreciate you.
Thank you.
Thank you. And again, thank you for coming forward. Hopefully this is a bill that we'll get through the legislative process this year, and we'll make some changes that will help you and help other people in your situation. So thank you very much.
Senator Kushner, have a good day.
Next up, I would call on number 14, Eric Getty from CBIA.
Great, thank you so much. As you said, Senator, my name's Eric Getty here on behalf of the Connecticut Business and Industry Association. And I'd like to start today by supporting Bill 5248 regarding the collateral consequences. Just as the gentleman said before, this is an incredibly important bill. Our state has one of the highest numbers of occupational licensing requirements in the country. Meanwhile, we have 110,000 jobs open in the state. Our workforce has shrunk by 92,000 workers. 80% of Connecticut businesses are having difficulty hiring and retaining workers. Frankly, it's the biggest issue that we face right now. And there's really no reason to impose barriers in statute for people attempting to earn an occupational license solely because they've had a felony on their record unrelated to the profession that they're seeking to enter. In fact, we put barriers in the way of people without felonies from obtaining licenses in the state, or at least recognizing their out-of-state licenses. So it's a pretty critical issue. And this bill will remove those barriers for people without forcing businesses to forego honest conversations with job applicants or requiring them to incur unwanted safety or legal risks. This is exactly the type of work that business and labor could be doing together to improve our state's economy. So again, thank you for raising this important bill. Unfortunately, I'm also here to oppose several bills, starting with HB 5429 regarding the non-compete agreements. I agree with a lot of what has been said so far this morning about non-compete agreements being unnecessary in certain industries. However, HB 5429 invalidates agreements of all hourly employees, all salaried employees making less than 3 times the minimum wage, all independent contractors making less than 5 times the minimum wage. These are unreasonable limitations that will impact a multitude of industries, especially given these agreements are already heavily restricted by the courts to ensure appropriateness of scope, geography, and duration. And they put at risk an employer's most important assets, their proprietary information, at a time when we really need it the most. Also here to oppose HB 5246 regarding extending recall rights. Last year's legislation imposed a number of costly new administrative burdens on certain businesses, and most businesses were caught completely unaware of this, especially given the effective on-passage date. And even if they had been aware of it, most couldn't comply with the letter of the law, even if they wanted to. You can't just mail employees about job opportunities under the bill. You also have to make sure you text them as well. You need to keep records about every job a person could be qualified for or what they could be trained to do. And these obligations extend to people you didn't even directly employ. So again, we do oppose that bill. And then finally, HB 5245 regarding arbitration agreements. For one, these agreements are not forced. Again, I just point out that, but in reality, arbitration is a cheaper method of dispute resolution that levels the playing field for people who do not have legal training. This bill seeks to deputize interest groups with the power of the Attorney General, just like the PAGA or the Private Attorney General Act in California. And that has been an incredible problem in the state of California. It's been heavily abused by plaintiffs' attorneys and imposing financial penalties.
Sorry to interrupt, but your 3 minutes is up. Please wrap up.
Senator, will you permit me? I have like 3 more lines, and then thank you. I appreciate that.
You can summarize.
Thank you. This imposes financial penalties for, in some case, harmless violations of law. Aggregated over every employee, over every pay period, can lead to financial exposure to the tune of millions of dollars. Nobody is safe from this bill. In California, the AIDS Foundation, the Humane Society, the Children's House of Los Angeles, and countless small businesses have all been victims. And further, when there actually were aggrieved employees, it has been shown that 75% of these cases have failed to protect the interests of those employees. So thank you for the indulgence of the extra few seconds. I certainly appreciate that, and I'm happy to answer any questions.
Thank you, Mr. Getty, and I don't see any hands, so thank you for being here today. And we will move on to our next speaker on the list, and that's number 15, Mary Valdovinas. Valdovinas, is Mary here? I don't see her, so I will go to number 16, and I do see you on the screen. That's Sarah Parker McKernan. Sarah, you can unmute yourself, and if you want to take yourself off, if you want to turn on your camera, you then. Here we go. Yeah.
Okay. The agency must give priority to projects that provide services to especially vulnerable workers.
Representative Anderson, yes, thank you. Go ahead, Ms. Parker McKernan.
Good afternoon, Senator Kushner, Representative Porter, and distinguished members of the Labor Committee. Thank you for the opportunity to testify today in support of HB 5249, an act concerning non-compete agreements. My name is Sarah Parker McKernan, and I am a legislative policy advocate for Connecticut's legal services programs. We support the language of HB 5249, which, among other things, prohibits non-compete agreements for those employees earning less than 3 times the minimum wage. A non-compete agreement prohibits employees from engaging in a particular occupation or type of work for a defined time period, and often in a defined geographic area after separating from an employer. Traditionally, non-compete covenants were intended to protect an employer's competitive advantage by preventing more highly trained and compensated employees from taking a job at a competing business and disclosing specialized knowledge and skills acquired at the former employer. In recent years, however, employers have required low-wage workers, including fast food workers and home health aides, to sign. These workers do not have specialized technical skills and are not privy to trade secrets held by higher paid employees. Even a 1-year restriction on engaging in the same type of work within a 10 to 15 mile area can adversely impact employment opportunities. Many low-wage workers do not have skills that are adaptable to other jobs, and they also depend on public transportation. Non-compete agreements can prevent them from seeking or accepting better jobs with higher wages and bars employers from hiring these often more experienced and more qualified employees. At-will employees in Connecticut have very limited bargaining power in their work environment. A non-compete agreement elevates their fear of violating their employment contract and losing their job. Workers very often assume that non-compete agreements are valid and enforceable and lack the financial resources to hire an attorney and challenge them in court. The power disparity between low-wage workers and their bosses means that workers with non-compete clauses often stay in their jobs instead of finding new and better jobs. It's important to note that HB 5249 contains provisions that help all workers in the workplace, not just low-income workers. HB 5249 extends the prohibition on non-compete agreements to some independent contractors. It also limits employers' ability to forbid workers and contractors from working a second job. But it also balances constraints on employers with constraints on workers. It forbids workers from soliciting a former employer's prior customers or workers after separating. Non-solicitation clauses and exclusivity agreements containing reasonable parameters are permissible within this proposal. We urge the committee to pass HB 5249, which protects low-wage workers who often live paycheck to paycheck from covenants not to compete. Thank you.
Thank you for your testimony and for all your advocacy that I know your organization has done for many years. I don't see any hands here, so thank you for being here, and we will move on to the next person from the public, and I believe that is, I don't know if he's here, but we have number 17, Jake Troy.
I am here.
I see you right there. Thank you, Mr. Troy. Go ahead.
Good morning, co-chairs Kushner and Porter, ranking members Sampson and Aurora, and members of the Labor and Public Employees Committee. My name is Jake Troy. I live in Gales Ferry, and I work as a 911 dispatcher for the town of East Lyme full-time and for the town of Ledyard part-time per diem. I am here to testify in strong support of HB 5251, an act concerning workers' compensation for dispatchers. I want to share a story with all of you that I feel is important and demonstrates how essential it is that we as dispatchers report to work every day, no matter what lies ahead in our daily commutes and shifts. I'm sure you'll all recall the intense snowstorm in January of 2015, Winter Storm Juno, that occurred and caused significant damage to southeastern Connecticut with extremely intense snowfall rates overnight. Connecticut residents had to literally dig themselves out from this freak snowstorm. During that blizzard, I had to do my job and report to work. At that time, I was 25 years old. It was 4 in the morning. The height of the storm was overnight. In an effort to make it in safely, I had to borrow my mother's Subaru Forester. It was right in the middle of this storm, and while I was trying to navigate my way through whiteout conditions, the state DOT stopped plowing Route 117 through Ledyard Center. I assumed it was because they couldn't see and weren't able to clear the roads, but nevertheless, I had to report to my job. I had noticed throughout the storm that even the police SUVs were getting stuck on the same road. I was so thankful at that time for my mom's Subaru, as the front of the car acted as a snowplow and plowed a narrow path for me to pass. There must have been at least a foot of snow while I drove to work. It was unsettling, but I knew I had to get to the police station. Normally, it would have taken me 5 to 7 minutes to get there, but during the blizzard, it took me over 45 minutes. It was intense, and luckily I didn't have an accident on the way there. As dispatchers, we do not have the luxury of staying home. And yet, we are still not considered first responders by the state of Connecticut or the federal government. Due to the imperative nature of our job, we must get to work. I had to be at my job that snowy morning to take the calls for help that continued to stream in. I was needed for a shift and a half, and at the end of my shift, I had to have a police officer drop me off at home because the roads were so treacherous. I left my mom's car at work for 2 days before returning to dig out. I knew that if I didn't make it into work, I would have to rely on other dispatchers who already worked overtime for 12 or more hours on earlier shifts to stay until I could make it there. I knew they needed me to show up so they didn't have to remain on the job for an unsafe amount of time. I do not have the luxury to just skip work. The bottom line is, as a dispatcher, you must make it in. It is a 24/7 operation. This bill is so important because the work that we do isn't about a paycheck. It's about the communities that we serve. It's about the panicking patients and family members that we provide medical instructions and comfort to when they are in need of immediate help and don't know what to do. We are truly the first ones on a scene providing guidance and changing outcomes. I urge you to support this bill as it would provide dispatchers like myself the support that we need. Please don't exclude us from the necessity of having workers' compensation. We need to be compensated like our fire and police colleagues who are also unable to perform the necessary work that we do from home. And we need the tools necessary to help us help you. Please pass HB 5152. I thank you for allowing me to provide testimony today, and I'd be happy to answer any questions you may have at this time.
Thank you, Jake, for being here today, and thank you for your work and your service. And we really applaud the work that you do. We know that you're part of the first responder team that's so essential to the safety of all of our communities. I do remember that storm very, very well. At the time, I was representing workers at Foxwood Casino, and many of them had trouble during that storm, and it had a huge impact on the whole area. So thank you for being out there and braving the elements to go to work. I do want to make sure that it's clear to folks that what we're talking about here, and maybe you can address it, is that under the workers' comp system, some first responders have availability of portal-to-portal coverage. In other words, you are covered once you get to work, but dispatchers are not covered for workers' comp when they're on their way to or from work. Am I correct about that?
Correct. And I think one of the things that is often overlooked is that we're not physically going out to a scene. We're using people that are already there as our eyes and ears. So we tend to think of dispatchers as someone who sit in a room, but we don't get the luxury to stay home during weather emergencies, hurricanes, snowstorms, major incidents. So I think it's important that people understand that we have to use our personal vehicles and things to dig out, to go into work. I just traveled to work in the recent blizzard that we had in the height of it, to and from. So, those type of things really should be covered as we put ourselves in danger to try and get to work to help you.
Thank you for that clarification. And I do recognize Representative Aurora.
Thank you, Madam Chair. And thank you, Mr. Troy, for your testimony. And I apologize that you might be seeing me on without video for parts of it because I'm on 2 Zooms, as many of us are, but I'm listening in and I appreciate your comments. I just wanted to a clarification, just to understand, this is the need for this relative to vis-a-vis other situations, is that what you're asking for is the coverage of workers' comp under this legislation would start from when your commute starts rather than when you get to the dispatch center. because of the fact that you really can't work from home, right? Is that, am I kind of reading this right, or I'm here, kind of understanding this right?
Correct. And I think that is one of the things that is a disadvantage for dispatchers still being considered clerical staff or secretaries, because we don't get any sort of coverage until we get to the physical building where we're working. And that to me is an issue, especially, some of my colleagues can drive up to 20, 30, 40 minutes to get to work.
And that would typically be more relevant in situations which you just mentioned, inclement weather and, times, in normal traffic or in normal situations, that's less of a relevant situation than in something when it's a storm or things like that.
Well, I would actually beg to differ a little bit, and that is, and I think Senator Kushner would back me up on this, knowing southeastern Connecticut. 95 from the Rhode Island border through East Lyme, Old Lyme, and into Old Saybrook is in desperate need of widening and is a complete and utter nightmare in the summertime. So even on a normal day for me commuting to East Lyme, which is now down near the Rocky Neck connector, it can be a severe challenge, and we can be in bumper to bumper traffic just trying to go to work on a normal day. And I've almost been involved in several accidents based on the negligence of others in that traffic, traveling through the area. So I would say even on a normal day, it can be a real challenge to get to where we need to go. And it definitely puts us at a disadvantage trying to get to our job.
Right, we're sympathetic to exactly what you're saying. It's just the comparative equity, and I know you're comparing them yourself with those in the law enforcement. But when you compare yourself to doctors or nurses, RNs, they have to be there, in surgery rooms and so on and so forth. And when we talk about grocery store, our workforce in the grocery stores who are also have to go there, they can't really work from home. So the question really here is a much larger one. That should workers' compensation be applied from the point you leave your house or from the point you leave the workplace, because there's a very large category of our workforce and very essential: doctors, RNs, nurses, CNAs, grocery store workers, all essential workers who are in a similar predicament as yourself. And, while in some ways you're very much akin to law enforcement, you're also as akin to a hospital, a doctor in some sense, right? So, those are the things which I just wanted you to kind of see where we are getting a little bit, I would say, have to think through that. But I appreciate your perspective and your input and your testimony, and we're going to have to weigh all of those things together and see if there's a bigger picture thing here, whether it is specifically for the dispatchers. But I will say, I thank you for taking the time and clarifying, because I was a little bit confused. Is it that you do not have any workers' comp at all, or whether there's a certain category, because there's some folks who don't get worker comps for one reason or the other, and we've heard about that as well. But if you are driving for a transportation, there are other situations and other circumstance. But thank you, and that's really my questions. And if you want to comment, please feel free, and otherwise I'll yield back.
I'll just make one comment to say thanks for remembering to mention other essential workers that have been so brave and traveling through to their jobs during the pandemic. My parents have worked for Stop and Shop as grocery workers for over 40 years. They met there in 1980. And, I think that certainly those people should be entitled to similar benefits. But I think one of the main differences between an RN or a grocery worker is that they work for private entities. I work for the public. In the municipal government agencies. And so sometimes those municipal government agencies need some prodding to move forward with things like workers' comp when we leave home to go to work.
Thank you. And back to you, Madam Chair.
Thank you. And thank you, Jake, for your testimony here today. I don't see any other hands. So I'm going to move to the next person on the list, but thank you for your service.
Thank you so much.
The next person is Rick Porter. I thought I saw Rick Porter here earlier. He's number 18, but perhaps not. I don't see him at the moment. If he comes in later, we will certainly call on him, but I will move now to number 19, Tyron Sampson. Good afternoon, Tyron. Go ahead and start.
All right. Hello, Representative Porter, Senator Kushner, and ranking member Senator Sampson. Representative Aurora, the distinguished members of the Labor and the Public Employees Committee. My name is Tyron Sampson. I am a smart justice leader with the ACLU in Connecticut. I am here to testify in support of HB 5248, an act concerning collateral consequences of criminal conviction on occupational licensing, a bill that would give people an opportunity to support themselves and provide for their families. I am fortunate to have a job right now. Actually, I was recently working 2 jobs, beginning at 4 in the morning and that end at 10 at night. I had to do this because I needed to be able to take care of my children. I am a proud father of 3 children. I recently had to resign from 1 job though, because the reality was that there's no time, excuse me. The reality was there aren't enough hours in a day for me to spend and be able to support my family and be able to spend time with them. I want to be able to develop professionally beyond the work that I do now. But my experience, the opportunities to move up in this company and take on more responsibilities are limited, if not impossible for a person who is living with a record. So instead of being able to work hard, grow, and earn a higher salary, I have to work multiple jobs to support my family. I was able to get a job now because I knew someone who helped me get hired. But I knew other men who have been denied employment, including at the company I work for now, just because of their criminal background history. When people living with a record cannot find work, it hurts more than just those individuals. More than half of people locked up right now are parents. So the barriers to reentry also harm Connecticut children when their parents return to society and cannot find jobs to support their families. A criminal conviction has unintended consequences of being a conviction for their whole family. And family problems will become community problems. Collateral consequences hurt each and every one of us. I hope this committee will note that more than half of our adults in the United States has a family member who has been incarcerated. The people who are turned into permanent underclass in Connecticut are not nameless. They are our children, our fathers, our mothers, our brothers, our sisters, family, neighbors, and friends. I will one day like to become an entrepreneur, start my own service company. I would like to be able to hire people. Like the men I know who struggle to find a job due to their record, I am concerned, however, that my record.
Sorry to interrupt, but your 3 minutes is up. Please summarize.
That my record to ability to hire people with record will be prevented by the discrimination that exists for everyone who live with a record. This is why I urge the committee to pass HB 5248 and help break down the barriers faced by people who are living with criminal records. Thank you for listening.
Thank you so much for your testimony, Mr. Sampson. And you make such an important point when you talk about the importance of people being able to take care of their families and the consequences if we don't remove barriers to reentry that would prevent people from being able to take care of the people that they care about and that we all care about most. So thank you for your testimony here today. I don't see any hands, so we will let you get back to work and we'll move to our next speaker. Thanks so much. Next up, I'll recognize Zachary McEwen. Did I say that correctly? From CCM.
Yep, Zachary McEwen. Good afternoon, committee chairs, ranking members, members of the committee. My name is Zach McEwen. I'm a senior legislative associate with Connecticut Conference of Municipalities. I'm here today to oppose SB 212, an act concerning permanent partial disability benefits and pension offsets. CCM appreciates the commitment our first responders have made to keep all of Connecticut's residents safe, and we support efforts to make our first responders whole when they are injured on the line of duty. However, the changes brought about SB 212 would create an environment where claimants receive greater compensation while they're out of work than they would have received prior to the injury they sustained. Lastly, many provisions concerning offsets are collectively bargained in good faith between the municipal employers and employees. The changes brought about by SB 12 would undermine the collective bargaining process. SB 12 would set a precedent that would enable future legislative action to invalidate components of collective bargaining agreements if any stakeholder is unhappy with the mutually agreed upon result. Accordingly, the provisions of SB 212 should be realized through the collective bargaining process. Thank you, and I can answer any questions anybody has.
Thank you, Zach, for being here and testifying today. I will recognize Representative Aurora.
Thank you, Zach. I really appreciate your insight and your testimony today. Question for you is that what is the driving factor you see for something like this? Because just as you said, there's already coverage, and this is a municipality. This is really for primarily applicable only to municipalities. So is there a reason even to think about this? What is the driving force? What is the other side of the argument? I don't, I can see municipalities really figuring this out, and especially the concern with the double pay or the lack of incentive at some point. But what is the other side that why should we, in some sense, I don't think that's a question to be asked to you, but maybe help me understand why would somebody want to do this?
Yeah, like you said, that might be a question for, the stakeholders that, want this legislation passed. On our side, I mean, if you can collect full workers' compensation benefits and full pension benefits, as we heard, in previous testimony today from the HR professional from the town of Guilford, it gives a specific, situation in which that can be enabled. And, the whole purpose of these pension offsets is to make sure that, somebody is not making more out of work than if they were employed. So, that's the position of the municipality. And I know there's disagreement on this bill in the past, but that, our municipal officials believe, want to respect the collective bargaining process. And they think that this could be sorted out through the collective bargaining process, which this bill prohibits. So.
Absolutely. And to some extent, what you do not want to do is create this incentive, which is kind of in some sense quite, not a real thing to be able to collect more than what you want. Although, there is obviously the other side of it. I appreciate your input, and perhaps I might have some more questions. I will plan to reach out to you separately for your thoughts on it. Thank you to you, and thank you, Madam Chair.
Sure.
Thank you, and I do have a couple of questions. I wonder if you could tell us, maybe give an example of a permanent partial disability, what that would entail.
Yeah, well, like I said before, I think the HR professional, that testified before this gave an example within the testimony that he gave, and he's also part of the CCM Labor Policy Committee that we have, that we lean on, a lot of their expertise to, to see, they have a little bit more of intimate knowledge of boots on the ground of, when they're dealing with these pension offsets. So they probably would be a better resource to go through the technical nature of these pension offsets. But I would refer you to his testimony on, a specific situation in which, an employee could, collect more while not being employed than if they were employed.
So I really wasn't asking about that aspect of the testimony. I was asking specifically, I think many people may not know what a permanent partial disability is. Forget the monetary part of it for a moment, but we're talking about specifically firefighters So what kind of injury might a firefighter sustain in the line of duty that would result in a permanent partial disability?
Yeah, I mean, I think, that would depend on, the individual circumstance of, how that would come about. This is a very, can be a very technical statute with the workers' compensation. And so, we rely on our HR professionals and, our workers' comp professionals to really kind of walk us through that if that, were to happen. So,
what I'm imagining, and maybe this is what most people might imagine too, a firefighter who's out fighting a fire in our community, and during the course of the fire sustains an injury. So falls off of a ladder in a way that is such a severe break of an arm that that person permanently loses the use of one's arm. Would that be, in your sense, what you know about this, would that be something that would be considered a permanent partial disability under workers' compensation?
I mean, I would have to lean on the expertise of the experts that, that would determine that. I would just, I can't really comment on that. I mean, I would lean on, the people that really work in this space and have an intimate knowledge and technical, knowledge of that certain type of issue.
Thank you. We will seek to get an answer to that from someone who's
Sure.
real familiar with permanent partial disabilities, because I think that's really at the core of what this bill is about. So thank you so much for your testimony. I don't see any other hands. So we'll move on to our next person on the list. Thank you for being here today.
Thank you.
Next up, I don't see number 21. Or 22. I hope if I'm overlooking.
Madam Clerk, she is on. I mean, it's me, Ju.
Yes.
Megan Lyon.
Megan, yes, she's number 23, but I was looking for either Brian Farnan or Olivia Rinkus, and I'm glad to see you are back, Madam Chair. Do you want to take over again?
I do not. I am actually still multitasking in a subcommittee.
Okay. Then without saying, but I'm glad you're back. You have some great testimony. Unfortunately, you'll have to go back and listen to the record because I know it was on issues that you care a great deal about. I will then move to number 23, Megan Lyon, who is here from the Connecticut CTLA Workers' Compensation Section Chairperson. That's quite a title.
Good afternoon, Chairwoman Kushner, Chairwoman Porter, and other members of the committee. My name is Megan Lyon, and I'm the new chairperson for the Connecticut Trial Lawyers Association's Workers' Comp section. So it's actually rather fitting to discuss the PPDs later. But I'm speaking to you today to vocalize the CTLA Workers' Comp section's support of 4 proposed bills: 222, 212, 5251, and 5250. So all workers' compensation statutes are traditionally humanitarian in nature and are of great importance to the welfare of the public. And the object and purpose of Bill 222 speaks to that overarching theme and helps protect injured workers from needlessly suffering from withdrawals. All too often, our claimants go to their local pharmacy to pick up prescription medication that was prescribed by their authorized treating physician, and it's medication that's been prescribed by their treaters and deemed to be medically reasonable and necessary. And all too often, they've been notified at the counter that their prescriptions have not been authorized. No warning, no explanation, just no refill. In workers' comp, claimants are entitled to various benefits and compensation from respondent's insurance company, and their medical treatments covered as well as various indemnity benefits to compensate for various stages of wage losses. In order for a respondent to discontinue issuing these ongoing benefits, Statute 31296 requires the respondent's counsels to file what's called a Form 36. What's this Form 36 and why is it important, right? The filing of this notice is important because it documents the insurance company's intent to discontinue these ongoing benefits. Upon submission of this Form 36, claimants counsel can then object to the notion, and we are then heard in front of a hearing. The issue is heard in front of an administrative law judge at a hearing to determine if the respondents can discontinue those benefits or not. Those benefits in question must remain issued and payable until the administrative law judge rules otherwise. So the language addition, the Bill 222 adds an additional language to Statute 31294D, which holds that all employers shall furnish all medical treatment, including prescription medication drugs, as a physician deems reasonable or necessary. Why then are our claimants faced with the unannounced pulling of their necessary prescription medications? So withdrawal is a horrible thing, both for the person going through it and for the loved ones and advocates that are witnessing them suffering through it as well. Attorney Spillane spoke previously about the issues that happened to some of his clients, and Bill 222 seeks to alleviate that pain and suffering from claimants. And by supporting this bill, insurance companies can no longer unilaterally and needlessly pull their authorization for prescription medication without the administrative law judge's approval. This way, a claimant will have notice, will have time to object and advocate for our client, and claimants aren't going into an emergency situation with painful physical withdrawal symptoms. The additional language to 31294D and requiring the Form 36 approval to discontinue medically necessary treatment also allows with consistency within the practice, and it says, if you wish to discontinue the payment of any sort of benefit, file your Form 36. So the CTLA strongly supports Bill 222. Additionally, we support the enactment of Bill 212, which prevents municipalities from offsetting their employers' benefits based off of their permanent partial disability benefit allocations that are awarded to them, aka PPD benefits. I think the opposition—
Sorry to interrupt, but your 3 minutes are up. Please summarize.
Okay, thank you. I think the opposition to 212 may be due to misunderstanding of the benefit, because PPD benefits themselves are different than other workers' comp benefits, to answer your question. And they're actually payments for the injured body part themselves. They're calculated by the percentage of disability identified by a treating physician, and it's to compensate the employee for the loss of use or function of their body part directly related to that injury. It has nothing to do with someone's wages. And if that municipal employee in question did not retire, they would be receiving their PPD benefits on top of their salary. So if they are now retired, their pension is essentially their salary. They should be getting that compensation on top of their salary as well. Also, we want to always support Bill 5251 and the expansion of the portal for the first responders and the dispatchers, as well as 5250 with any minor technological changes to the Workers' Compensation Act as needed. Thank you. I'm sorry for going over. If you have any questions, please let me know.
Thank you so much. And yes, normally I would have cut you off much more firmly, but you were answering a question that I asked a previous person who was testifying. So I felt like I gave you a little bit of leeway there, but I do want to go into a little more depth because I think it is a confusing, technicality that it took me some time to understand, and I really had to delve into it. But I think you're the perfect person to describe what is, first of all, please describe in more detail, like give us some examples of a permanent partial disability.
100%. So the way I explain it to my clients is that the doctors are trying to take your subjective complaints and put it into a quantifiable amount. So what they do is they take into consideration your limited range of mobility, your limited strength, and your loss of use of, say, your arm. If I had a shoulder surgery and I had a torn rotator cuff from falling off a ladder, if I was a fighter, I would have my rotator cuff repair, but I may not be able to lift as much weight as I otherwise had previously. I might have some weakness, it might keep popping out and subluxing every once in a while. So what the doctor does is they give, all right, your arm is as good as it's going to get with treatment, but it's compensation for the fact that it's not going to be 100% anymore. So the doctor may prescribe, say, a 15% disability rating. So pursuant to the statutes, we have 31308, and what it does is it itemizes each body part and explains how many weeks of benefit each body part is worth at 100% disability. And there's a calculation. So if it's a 15% disability, it's 15% of the total allocation of weeks and of the total allocation set forth in the statute. And then you're able to get compensated for that diminished capacity capacity and the diminished use of that body part. And if you're still working, that's payable on top of your salary, because it's saying, hey, sorry, your arm's not going to be the same again, but here you go. Here's an issue for some compensation for that. So they'll get their straight, full duty, average weekly wage payment. And on top of that, each week, they get the PPD benefits. So that's
really helpful, because I think that the issue became confused because it gave the impression that we were trying to accomplish something that would allow for double dipping, that you'd get more than you were entitled to while you were working. But I think what you've made clear, I hope for everyone, is that what we're talking about is a person who in the line of duty, serving the public, a firefighter very specifically we're talking about here, would be entitled to the full compensation for that permanent disability sustained because of work. So this is someone who might be able to continue working, but will never in their life have full use of that body part. And so as a result, we're saying as a society, we're going to compensate you for that loss that unfortunately happened to you in the line of service. And so that is a specific dollar amount that the person is entitled to based on a formula we use. I think you mentioned in your testimony, and again, I'd like you to emphasize it so everybody is clear. If the person is able to go back to work, they would get that full amount of pay while that full amount of compensation, it's not pay because it's not a wage, but that full amount of compensation while working and getting their wage. So this is a system that was set up to compensate someone for a loss of a body part or partial loss of a body part. While continuing to work, they would get some compensation for that. The difference is if the person retires, they don't really get compensation for that because it's taken out of their pension payment.
If the municipalities were allowed that offset, they wouldn't get the proper compensation for that. Now, the act of the 212 also addresses 31308A benefits, and that's a wage loss supplement, so that if I was a laborer, a fireman, and now I hurt my back and I can no longer make as much money as a fireman, and now I'm answering phones as a clerical position, I'll get an offset from what the wages I get now for the wages that I was getting. But you're not eligible for wage loss supplements if you've already removed yourself from the workforce. So if you're retiring and you're in pension, and you're getting a pension, you've removed yourself effectively from the workforce, then 31308 isn't always going to be eligible for you. So that wouldn't really, I don't see that being too much of an issue, but the PPD would be an issue because, again, if they went back to work, if they, thank God, had their surgery, went right back, and they're able to continue working as a firefighter, they would still get that payment awarded to them every week.
Well, I really appreciate your testimony, and you came at the perfect time because I've been looking at this issue and I was getting confused myself, and it's very helpful to have it like very specifically laid out so we don't have to be concerned that someone is double dipping and getting more than they would have earned on the job, because what really they're getting is compensation for partial loss of a body part.
And that prior testimony about there being this lack of incentive to return isn't there, because they'd be getting the same amount anyway if they did return or if they didn't. It's quantifiable, it's a mathematical equation to calculate it.
Thank you very much for that clarification. And I see Representative Aurora, who I know has concerns about this as well.
Wonderful.
No, I just want to thank you so much, Ms. Luan, for being here and for your time and your testimony, because we're just trying to understand. So the 212, which we're talking about here, right? 212, that's, the way I read it, it's applicable only to firefighters or for any municipal employees, the way you see it.
So it'd be for any municipal employees. So there might be police officers or anyone that has a pension or a retirement plan payable through the city. So I was just using firemen because Chairwoman mentioned in her hypothetical a fireman that had fallen off of a ladder. But yes, it would be for any municipal employee. I have a bunch of police officers now, and it is important to go through the collective bargaining agreement and look to make sure that there's an availability of those there. But that speaks to people that are medically disabled or forced retirement and unable to do that career, but they're still always payable for PPD. That's always an issue. That's always allowed.
Got it. No, I just wanted to clarify. There's no, it's not it's just I want to understand, because one of the part of this process is we get to understand. You can read, I'm not a lawyer, but I do get to read all of this, and I've gotten a little better at it now. Now I've been doing this for a few years, but we appreciate the expert input into it. And it can be any role, whether you could be in the town hall for a role, or you could be a police officer, as you said. But the question here is, this is not 212 is not if you go back to work. 212 is if you are basically not working anymore and you're getting a pension. And what we're saying is there's a PPD benefit, and what they're saying is that just trying to clarify, I don't have a view either way, is that the overall, if you do both, if you provide the full pension as well as the PPD, then the person may end up in a spot where you had to pull back, you didn't want to, you're not working anymore, and that's the question. So this is not related to you going back to work. This is related to you're retiring, either because of that, or you worked a few years after it, and then you say, well, I'm retiring. And the question here is, okay, let's say you worked 5 years after an accident, and 5 years later you decided to retire. And the question here is that the pension system right now will say, well, you're getting this dollars from the PPD. I want to reduce my pension by that dollars so that your total pension stays the same because you're not working anymore. Is that what the CCM or municipalities are like? Well, we should be allowed to take the offset. Am I understanding this correct? That this is only the case of somebody retiring?
Yes, you are, Representative Aurora. The point that I was making about returning is that you can quit the job as soon as you can quit the job whenever, and they're payable that PPD. You can return to work, the PPD is payable. You can retire, the PPD is payable. So that's just the particular benefit in that situation, that it doesn't matter where you're working or the status of your work capacity. Once you get that permanency rating, it's a mathematically quantifiable figure that you are entitled to for the injury. So yes, in this particular instance, they're saying that you're retired and you're getting this pension. But I was just kind of making a point that your pension in this case could also be the supplement for your salary. And regardless, you're still getting PPD on top. So that's what I was making. But yes, correct. 212 does speak to retirements and pension.
And I totally understand. No, this you really helped me clarify it. The way to think about, and perhaps I'm rehashing, is that you get the PPD irrespective once that you have been, obviously you got hurt at the job, you've been disabled, you have a partial permanent disability, and so you're going to get paid that amount, whatever it is, one unit, 25 grand or whatever it is, or $500, you're going to get paid every month for the rest of your life. And then what we're saying here is that the municipality, at some point you stop working, and if you're working, you're getting your job, your pay in addition to that. And perhaps I think Senator had pointed out that maybe you're earning less now, so it's a fair thing. But then when you retire, you basically get that, and I guess the question which came from the municipalities is that when you're working, really, you're still working, so there is no additional. Both of these pools are coming from the same municipality, the pension and the PPD. That may be their point of view, and I'm just thinking out loud here. And when you're working, basically that's the pay they would pay. Even if you didn't work, they would have to pay someone else. So I guess that's where they're coming from. But anyways, thank you very much for helping clarify, because some of this stuff, you want to get into understand it really, really well. So thank you for that. And any comments you would like to make, and back to you, Madam Chair.
Well, I think that I think what we need to be clear about, and again, I know that I think you testified about it, but if you could expound on it. When you get a payment from workers' compensation, first of all, let's be clear, it has to be an injury that was incurred during work. Right. So not like grocery store and you slipped and you fell, and you have an injury, a permanent injury to your foot, that's not work related, you would not be getting workers' comp to begin with. So let's first of all make sure everybody understands we're not talking about every person works for a municipality and has some injury and permanent disability. But what we're talking about is somebody who in their work, which is most frequently, as you talked about, I think that's why we talk about firefighters. And as you said, it also happens to police officers, but it has often, it might happen to someone who's working for construction in for the city. But these are the kinds of work injuries that we're used to. When it's a permanent partial disability, there's a set dollar amount, often paid out over a period of weeks, but limited to those weeks that would total the amount you're owed under workers' compensation. So in other words, whether you're working or you're on your pension, we're not talking about a payment that goes on indefinitely. It's a limited amount of money and time. Is that correct?
Yes. So I was actually just grabbed the statute book so I could explain it in a little hypothetical. If we have our injured fireman who has a 10% disability to his lumbar spine, right? The total, here's the statute portion of it. It lists out all these numbers of weeks. So at 100% disability of a back, which no one has, it's 374 weeks. So if the doctor prescribes a 10% disability percentage to him, he's only payable for those comp benefits for 37.4 weeks. So he'll have a 10%, and then for 37.4 weeks, that means each week he will get his basic comp rate payment on top of his salary or on top of his pension. So it is capped. So it doesn't go on for forever. It's just there's a chunk of period in which that would be payable. And it's supported by medical testimony from the doctor.
We lost you. I'm so sorry, but I think it's Megan. I think your internet is unstable. We lost you there. You're frozen. I'm sorry, but I think we lost Megan. You all can hear me, correct?
Yes, if you could make the suggestion that Megan mute her picture, that tends to help a little bit.
Megan, if you turn off your camera, we might be able to hear you better. Right now you're frozen. And I think she may have dropped altogether. It's too bad, but hopefully if she comes back in, we can ask her that question. But I believe what the point of this, I believe, is that this bill would say that regardless of whether or not you continue, she's back, good. So you were frozen, so if you could answer, I was gonna try and sum up what I thought you were saying, but go ahead and answer.
Yes, I'm so sorry. Of course, I lose internet now, right? But yes, so basically there's a permanency rating that is medically supported by a doctor's opinion. The doctor gives a percentage, we put it into the statute. It allows us to document out exactly how many weeks of benefits that they're going to receive on top of their salary if they're still working, or in this case, on top of their pension. And then once they are able to, and then once that period is exhausted, that in this situation, the 37.4 weeks of benefits, then their benefits are over. So it is a finite period that we're discussing. And that's just the difference that we have as opposed to an indefinite period of temporary total disability or temporary partial disability with the wage loss supplements. This is a finite equation, medically supported. Mm-hmm.
Yes, it is important. So I think the way we could look at it is if you're still working and you were entitled to, a certain number of weeks that totaled $4,700, you would get an additional $4,700 for that partial disability on top of your earnings. However, if you're entitled to a pension, if you're now on a pension, your pension would be reduced by any amount that hadn't already been paid out. It could be the full amount of $4,700. So essentially the argument could be made is you're not getting any compensation for that permanent partial disability if you retire from the job because your pension is basically paying for your permanent partial disability. Is that a good way to look at it?
I must disagree. I'm sorry, because the pension should be the salary. I'm viewing the pension as your payment, right? So that's your weekly payment that you're getting as your pension payment. Completely separate from that is the PPD payment. So just because it's coming from the same municipality, same bank per se, it's rather unfortunate, but it's still necessary because it's still, you're getting paid for that injury. You're not getting paid. So I'm getting paid for my shoulder, which is injured. I'm not getting paid. My pension shouldn't be offset because I accidentally got injured. Does that make sense?
That's exactly what I'm saying, is essentially you would have gotten the $4,700 if you'd continued working, but now you're not going to get that $4,700 if you're retired because it's going to be offset by your pension.
Yeah, and this in 212 done that.
I think that unless we fix that with 212. Yeah, I think that we were saying the same thing.
Sorry.
But, you know, I might not have been clear, so I think it's always best to get it from the person testifying because you are an expert in this. So I don't see any other hands, but I want to thank you for coming in and clarifying some of these issues that we're confronted with. It was incredibly helpful.
Thank you. If you need anything else, please don't hesitate to reach out.
Thank you so much.
Thank you, everybody.
So next, I think, I'm looking at my list, and number 24, I don't see Amit Patel or Patel. I don't see Amit is here right now. Hopefully, I know sometimes people can't get on right at the moment that they're called, but might show up before we're done. After 24, we would skip to number 26, Danielle Edwards. Is Danielle here? I don't see Danielle. So we are now at number 28. And I think I saw 28, Ken. Yes, Ken Girardin. Did I say that, Girardin?
Thank you, Senator. Thank you, Representative Porter. Thank you, members of the committee. Most of this is already submitted in writing. I'll give you the top lines here. The Department of Labor issued their technical corrections. They are encapsulated in Senate Bill 210. I would urge members of the committee to look very skeptically at this list. And there is one section that the department has identified as obsolete and that they have occasionally in public remarks mischaracterized. It's called Section 3177 of the Labor Organization Statute. This is a bill that was signed by Governor Abe Ribicoff and back in the 1950s, shortly after the national drama around the Teamsters, where that's where Robert F. Kennedy made his name nationally, identifying misconduct in the Teamsters. The state passed a law to prevent that sort of stuff from happening in Connecticut, and this preceded any kind of federal rules. Federal rules came a couple of years later in 1959, and so for on and off for the past couple decades at least, there's been this confusion about whether Connecticut still needs to have a statute on the books about essentially guaranteeing that any union member gets an annual report, that they can go to the labor commissioner if they have a problem with what's in that annual report, and making sure that they do have access to that report if they aren't personally given one. This is a really important thing because things happen. Union dues get stolen on a pretty regular basis, both in the private and public sector. In the private sector, union members have recourse by going to the U.S. Department of Labor under the LMRDA rules. But in Connecticut, they rely on state law 3177 to get the labor commissioner involved to help straighten stuff out. Unfortunately, the labor commissioner speaking last month described that as an obsolete and redundant statute, which kind of seems to confuse how public sector union members don't get federal protections in most instances under LMRDA. And Senator Kushner, I see I've got you at attention with my mention of the 1959 LMRDA. I'm a labor history buff myself, so I'd encourage members of the committee to just look skeptically at their characterization of something that's really, really important as obsolete or redundant, because that's not the case.
Thank you, Mr. Girardin. I don't see any hands. So thank you for being here today, and we will move on to our next speaker. Next up is Amy Epler here.
I'm here. Good afternoon. Thank you so much for the opportunity to address the committee. I'm here in support of HB 5248 and some hopeful amendments to it. That's an act concerning collateral consequences of criminal convictions. And I had been hoping to see from the committee such an act dealing with employment consequences generally. This act is limited to licensing, occupational licensing. And although we support this bill, for my clients at New Haven Legal Assistance, that's not really what affects most of them. The people I've been working with on a daily basis who have criminal convictions are just having a hard time getting a job. And so I want to endorse and support the testimony that you heard earlier from members of the ACLU and the Smart Justice Campaign and Jess Zaccarino about urging this committee to amend the language to make it broader so that it can address employment generally. And the standard that the Collateral Consequences Council had proposed and that we're hoping to see this session is a standard that would basically apply the same individualized assessment that the state currently requires for state employees to private employers. And so that is an opportunity for somebody who's applying for a job and who has a criminal record to have that employer look at them not just as a number, not as a statistic, not as their worst actions and what those convictions look like on paper, but to talk to them, to find out from them what has happened in their life, what has changed in their lives, what mitigating circumstances might there be, what rehabilitation might they have gone through, how long has it been since they've been employed, and what they can bring to this job. And I think what we've seen around the state is employers who do that often find that their employees who have criminal records are some of their best employees and some of their most committed employees because they really need that job and they really want to be there and they appreciate getting that second chance. The law as it's written now only requires that opportunity for state employers, for somebody applying for a job with the state. It should apply to all employers so that all prospective employees have the chance to show them, to prove themselves and to be considered for the person they are and the skills that they have to offer right now. The one other suggestion we would add is that I think the law as it's written now, even for state employers, doesn't make explicitly clear that the state or the employer has to provide a written notice to somebody that they're giving them this opportunity and a chance to sort of show these kinds of things. I think that would be, if this committee agrees to amend the bill to cover all employers with that broader standard, I think the bill would benefit greatly by just having that clarity to say that that employers in considering a criminal record have to give a notice to the prospective employee of what information they can provide in a time frame in which to do it so that people have the opportunity to give that information and to at least have that kind of individualized assessment. So I thank you for your consideration and happy to answer any questions.
I want to thank you for not just for being here today and testifying, but for the work you do and also for your role in the Council on Collateral Consequences. It was an opportunity for me to learn a lot about a subject I knew very little about previous to being in the legislature. And I think that your points here today are well taken. I would encourage you to be in touch with the chairs, with myself and Representative Porter. And we would certainly look at any amendments that you might consider necessary to make this really work for the people we're intending to help and for the obstacles we're intending to remove. I think particularly in this era where people are often applying for jobs, almost exclusively applying for jobs online, I could see where that could be a huge obstacle because they don't even, it's not even like the old days when you could walk into an office or walk into an HR office and the person would see you and maybe identify with you in some way because you're there physically in person. Online, it must be an even bigger obstacle. So
I think that's true, but I also want to point out, I think some of the Smart Justice folks talked about this, and I have certainly found this with many of my clients. I've had clients who have gotten a job because the ban the box requires them to be looked at for their capabilities and their their qualifications. They've been found qualified. They've been offered a job. They start the job. People like the work that they're doing on the job. And then the criminal background check comes back and then they are dismissed. I've seen this multiple times, and it's so disheartening and so disappointing for people. And there's no recourse right now. There's nothing that they can, they can't really do anything to get the employer to do anything different about it. And the law doesn't, well, with some exceptions in fair employment, if there's a sort of racial disparate impact or a blanket policy, but in many cases, there's really nothing that requires the employers to do anything more than that. And so we would really love to see some changes made in that law to give people, I think society agrees that people should have a second chance and that they should not, as one of the previous witnesses spoke about, your sentence isn't over when you leave jail and then it turns out that you can't get a job and you can't get housing. And that's not as it should be. People, if we want to be a second chance society, then we really need to give people this opportunities to work, to get housing, and to move on with their lives in productive ways. And so many people want to do that and find the barriers to be just huge.
And so what you're recommending in an amendment is that in that case that you just laid out, where a person's background check comes back and they are dismissed because of a criminal record, in that case, the employer would be required under this, if we took up this amendment, to do an individual assessment and have that person sit down and talk through.
Right. And certainly part of the factors they could look at is the evidence that they've given in their job work, that they are able to perform the job well in this environment and that the record should not be held against them.
Thank you. Thanks for helping me to understand that better.
Thank you so much.
I don't see any other hands, so thank you for being here today and for all you do.
Thank you.
Connecticut, and we'll move to our next speaker. And that would be Eric George from the Insurance Association of Connecticut.
Hello, Senator Kushner, Representative Porter, members of the Labor Committee. My name is Eric George. I'm the president of the Insurance Association of Connecticut. And the IAC is a state-based trade association representing the property and casualty industry in Connecticut, as well as the life insurance industry. We're here to offer comments on a few bills. The first deals with non-compete agreements in House Bill 5249. We oppose this bill. Non-compete agreements provide protection for all businesses that utilize them, including insurance companies, from the loss of trade secrets, emerging technologies, and other confidential and proprietary information. These agreements are already significantly restricted by the courts to balance the interests of the employers and the employees, while ensuring the appropriateness of scope, geography, and duration. However, under 5249, the new restriction would remove the protections non-compete agreements provide in circumstances where they're needed most. It would render void any non-competes where the employment relationship is ended, where the employee terminated the employment relationship for good cause. Thus, an employee who mistakenly believes they had good cause to end an employment relationship could cause irreparable economic harm to the employer before a court could validate or invalidate their claim. Non-competes and exclusivity agreements provide critical protections for insurance companies that use them. Going on to the next bill, which is the discontinuation of prescription medications. We do oppose Senate Bill 222. This bill would require notice be given, and while it is seemingly benign on its face, this would be quite burdensome and costly because it would require significant costly changes to the workers' compensation insurance company systems and processes, and that's not anything that happens quickly or easily. Any proposal that would have the effect of increasing costs, we have serious reservations about, specifically in the eventuality that a medication is discontinued. Senate Bill 222 would apparently require in each circumstance a very laborious and peer-reviewed analysis. This would cause a considerable amount of new work, which again, might not be the best use of resources and would have a cost component. We do have a question how this bill would impact those instances where a brand name medication was being substituted with an equally efficacious generic equivalent. As we all know, generics provide cost savings without sacrificing efficacy. The last bill I want to talk about is the House Bill 5251, dealing with workers' comp for dispatchers for portal to portal. This bill would allow dispatchers who are employed by either a public or private public safety agency to file a workers' comp claim for injuries sustained on the way to work or the way home, regardless of whether they're responding to a request of their employer or in response to an emergency. Workers injured during the normal commute to and from their workplace are generally not entitled to workers' comp benefits under what is called the coming and going rule, because that injury did not arise in the course of the employment. But it's important to note that there is an exception to this rule. There is an exception for workers injured while driving to and from their work at the request of the employer and in response to an emergency. They are then covered under the workers' compensation system. You can refer to my testimony, my written testimony, for greater explanation here, but I wanted to thank you for your time. You've had a very robust public hearing today. I am mindful of your time, and I am here to answer any questions that you might have.
Thank you, Mr. George, and I do see a hand. Thank you for your appreciation of the robust dialogue. I agree with you. It's been a good discussion today. Representative Aurora.
Thank you, Madam Chair. Thank you, Mr. George, for your testimony and for being here. We really appreciate it. I would like your comments on, something we've been hearing earlier, that in many industries, and I would like your comment on insurance industry as well as others you would be able to, the managements and businesses use non-competes indiscriminately for everyone, and all the way to minimum wage employees, to basically curtail them to retain them or to reduce their pay. Is that the experience you see in your industry?
Thank you for the question, Representative Aurora. That is not the experience that I have seen in the insurance industry. I cannot speak for other industries as to how they operate, but non-competes can be very useful for certain classifications of high-level individuals within companies that have access to certain information and such. But in terms of a blanket rule, that's not my experience.
Thank you. Thank you for that answer. For some of the elements which we heard for people using them is that you would give, special client list who has really been very lucrative. And, now, there may be 5,000 buyers of insurance, let's say, of which, these 80 people are really good. They normally buy, and you have to call them, and it's a good pitch, and you have identified that, 25 years of service and so on and so forth, those clients. And now this person has those clients, you disclose that client list, and basically they have it, and they say, well, I got a client list. They call the first 5 and they say, wow, this is a gold mine. I make X dollars, and I'm part commission or part bonus incentive. See you later. And then, would that be some situation where it would harm the insurance, and I'm just taking insurance, it could be a lot many other businesses, because there's some degree of kind of, understanding that minimum wage employees, if you are basically, helping, minimum wage employees, we find it very hard to see why you would do it. But when you have such situation, would that, in your opinion, really harm the business? And yeah, go ahead.
No, I mean, think about it like that. I very much appreciate the question that you just asked. If you think about it like this, if you are the outward face of your company, whether it's an insurance company or something else, but I'll speak to insurance, and you develop the relationships with the various clients, there does come a point in time where the relationship almost resides more with you than it does with the company. So the reason that relationship developed was because of your position within the company. Now you're just really good at what you do, and you are very affable, and people just really like you. So if there is an opportunity for you to leave and grab those clients, that is absolutely to the detriment of the insurance company. And I can also put on, so not only do I represent the insurance industry, I am also a registered lobbyist. And we've seen this in the lobbying community. I'm not going to go into any detail at the risk of getting all of my fellow sistren and brethren very upset at me. But we have seen this where the relationship is created and then, you know, it is the company that is harmed. So there are very good reasons why insurance companies want these protections in place, but it's also understandable that they're not appropriate in all instances. They're absolutely not. So I think that our current system of balancing those interests is very good, but those are the comments that I would offer to you, sir.
Great. Now, if one were to think about this legislation limited to minimum wage employees only, would that be something which you would say is it's a reasonable protection, or would you really have any concern even with that, something like that?
So it'd be very inapplicable to the lion's share of my industry because we pay higher than minimum wage almost across the board. So I would defer to those groups that generally hire and employ minimum wage folks for their response, because in our position, we're already paying above minimum wage. So for us to comment seems a little, it doesn't seem right, if you know what I mean.
I congratulate. I
think groups and employer groups who actually do employ minimum wage level folks, and by the way, critically important to Connecticut's economy, they should be offering their comment on that.
No, great, thank you. No, I do appreciate the fact that you're paying higher than minimum wage to all your employees. That's a good for us as
I can't say all, but generally, I mean, generally speaking, the wages that you earn in the insurance industry are you know, there's a reason why it is very sought after to be in the employ of insurance companies. It is because not only do you have good base wages, but the benefits are also phenomenal too.
No, that's great to hear. I think Connecticut, one of the things we always are proud of our insurance industry, because it's been Hartford, I think we used to be called the insurance capital of the is that right?
Oh, well, no, and I would say it's not since. We are currently still the insurance capital of the world. Oh. And I will not allow that title or that moniker to go away. We are still the insurance capital of the world.
I'm very delighted and excited to hear that we still are, and I hope we always will be. And you know, I might reach out to you separately for a question or two with regard to this clarification here. I think that's all. So the other one you had testified was 222, right? And is there some changes to 222 that you would require to, if that law were to proceed forward? Are there any changes you think will make it more reasonable, or is there any amendments or changes which you would ask for in that, or do you think it's totally a very difficult proposition for the industry?
So I can't offer any, bless you, Senator Kushner. It happens to me all the time. It's hay fever season's coming right on us, Anna. So I can't offer you any amendments at this time. I could have a conversation with my folks to see, let's see where everything goes with the legislation, but I can't offer you anything at this moment in time, Representative Aurora.
Thank you very much. That's all I had, and appreciate your time and your testimony. And back to you, Madam Chair.
Thank you.
Thank you, and thank you, Eric, for your testimony. I see no other hands right now, so we will move on to the next speaker on our list. Next up, we have Jeffrey Tomczyk from number 31, and I have to say, and also a constituent of mine, so it's good to see you here, Mr. Tomczyk.
Thank you, Senator. Thank you. And good afternoon, Honorable Chairwoman, Representative Porter, who I know you're listening, and Senator Kushner, as well as Ranking Member Senator Sampson and Representative Aurora. I appreciate your time and commitment, as well as the Labor and Political Employees, Public Employees Committee. As the Senator said, my name is Jeff Tomczyk. I'm with the Uniformed Professional Firefighters of Connecticut, and we represent 60 local affiliates for the International Association of Firefighters. Membership in the UPFFA is approximately or over 4,000 firefighters across our state of Connecticut. I'm providing testimony today in support of Senate Bill 212. My predecessor, Rick Hart, last year gave similar testimony to a similar bill that was presented, and he gave specific detail on the history of workers' compensation and how that negatively impact the workers' pension benefit. Today, I'm going to continue defining the difference in the injury benefit, a workers' pension benefit, and how this bill applies. We know that all forms of trade and vocations provide vital services to improve upon the infrastructure, public safety, education, and social services, just to name a few, that serve and better our communities. Even with significant advances in occupational safety standards, there still exist inherent risks that may lead to worker injuries. When these injuries occur, teachers, firefighters, police officers, social workers, and other employees have come to expect and justly expect compensation for injuries that occur through the course of their employment. This is a natural process that a worker must navigate that has been developed, implemented, and regulated by the Connecticut state statute. There are generally no issues with receiving designated compensation for injuries based on the Connecticut General Statute 31-308 and the schedule contained therein, providing, and I quote from the statute, compensation for total and partial incapacity or for a specific loss of a member or use of the function of a member of the body. And the employee, hopefully, unfortunately, will be able to return to work. In addition, the Office of Legislative Research Report 2000-R-1180, and I quote again, PPD benefits are for loss of body parts or a reduction of function in that body part. These clearly define that PPD is a benefit and not a wage replacement or a specific wage at all, meaning it is intended to make the worker whole for the disability sustained at work that would clearly not have happened or normally occurred in the course of one's daily life. This is clearly defined, again, in both sources, that it's not a salary or a wage replacement. In the absence of a bill, a practice of a contradiction occurs. When an employee is injured so severely they're unable to reach medical maximum recovery, which would allow them to return to work, employees are compelled to retire with a contractual disability pension. When this pension is offset by the corresponding permanent disability the PPD or the permanent partial disability payment warranted through and defined by workers' compensation, it's considered an act of garnishing the pension and can be construed as punitive. Again, the definition in the statute, compensation for total or partial incapacity or for a specific loss of a member or use of the function of that member of the body, is in fact causing the employee.
Sorry to interrupt, but your 3 minutes is up. Please summarize.
Okay, I will summarize. Thank you. This is causing inattention is causing the employee to pay for his or her injury. On the contrary, as we were heard earlier, if the employee is able to return to work, 100% of that PPD will be applied to the employee, as well as receiving 100% of their salary. This inherently creates a contradiction and is clearly wrong and needs to be fixed. This contradiction, therefore, needs to be repaired through statute, and the UPFFA is requesting that the Senate Bill 212 is moved forward. And again, as Mr. George had said, I appreciate your full day of hearings here and your dedication to all the time. If I would certainly entertain any questions that you have.
Thank you, Mr. Tomczyk. And I have to say, we thank you for your service, not just as a firefighter, but specifically as a fighter in my town of Danbury. So I really do appreciate it. Active firefighter. The other day I was going to see you at an event, and you warned me that if you were able to come, you would be in full firefighter gear, and I was so looking forward to that. But then you got called on a call, and I didn't get to see it. So But I do think that we appreciate the service of our firefighters. I have a couple of questions, but before I get to them, I'm going to recognize my co-chair, Representative Porter, because you have been waiting a while. You had trouble getting back on, but we were happy to see you here.
Thank you, Madam Chair. And yes, unfortunately, there were some technical difficulties and I was inadvertently removed from the hearing and had an awful time getting back in, but I want to thank those that made it possible, and here I am. Also multitasking in an appropriation subcommittee. So I did want to actually thank you for your service as well, Firefighter Tomczyk. And I wanted to see if you could speak to, do you have any idea the number of firefighters that are impacted by what we're trying to address here?
The specific number of impacts, I don't know. Of course, the previous speaker, Miss Lyon, I believe her name was, had indicated that there are so many variables in the workers' compensation process, and she proceeded to show the list of percentages and how that applies. And of course, involved in that as well is some HIPAA violations on passage of information. So it's difficult for us to ascertain a number who is specifically impacted. What we do know is that it is variable across the state on which municipalities actually participate in garnishing a pension on the award of a PPD. And at this point, it is, I believe, 6 municipalities that do participate in that activity. Fortunately, in our city, the mayor had the conversation with our firefighters and decided that he would not make this applicable because he doesn't believe that is I apologize. The former mayor made that statement, and he didn't believe that it was fair under the understanding of what the PPD award specifically represents, opposed to what the pension benefit is purposely for.
Well, thank you for that. And I think that does help to shed some light on what the problem, what it really is when it boils down to it. So thank you again for making the time to be with us today. And thank you for your testimony. Thank you, Madam Chair.
Thank you. And I'm so glad that you asked that question, Representative Porter, because I think up until now, we had lost sight of the fact that there are many municipalities that do award the complete PPD payment in addition to the pension. I think that may have been lost in the discussion. So if I heard you correctly, only 6 municipalities now are using this offset?
Yes, it's our understanding, yes, as we get information coming in.
That does really underscore a question that I have, is if other municipalities and cities can do this, I wonder, I would be concerned that we have some outliers here out of 169 municipalities in the state. I have a couple of questions, but I see Representative Aurora has his hand up, so I will call on him and then I'll come back for my questions. Representative Aurora.
No, thank you, Madam Chair. I think that was really very important information, right, what you pointed out, and Senator Kushner, you underlined. So, I just want to get the number right. So there is data out there from who would have so as to say, who would be able to really confirm for a fact or have the data that the other 163 are already following the practice of not constraining PPD in the pension payment, because in some sense, in that case, it's already some degree of practice, and it makes much easier from someone like us when we're trying to see the cost benefit or the reasonableness of it, that if 163 municipalities already are doing it, then perhaps that gives a much, people's actions are much more important than are equally or more important than their words. So to the extent that is that something which is quite well known or confirmed, that most municipalities do it. It's a few municipalities here and there which still do the offset.
That's a great question, and I appreciate it, Representative Aurora. But understand that my constituent base in this capacity is specifically regarding career firefighters, which obviously would not apply to a full 163 municipalities. And so narrowing that field down to municipalities that do contain career firefighters, it is incumbent upon, obviously, the retiree who experienced this issue to then report that information to either their local union or the state UPFFA affiliate. And that's the difficulty in us ascertaining a full complete data set on how that operates. And where the situation comes into play is you have a firefighter that becomes injured in the line of duty, and his doctor, of course, a treating physician that is approved by the workers' compensation system, identifies that he or she has reached a certain level or percentage of incapacitation. Then we have to revert back to the standards for the job specs itself, and most likely will rely on the NFPA standards on whether that individual can return back to work with that decrease in mobility in the afflicted body part. Once that is determined, they will naturally file for their pension if they cannot. And once they enter that pension system and become a retiree, we're really talking about a person who is no longer protected by their union, and for them to take on a legal battle in order to have the statute or the legislature or the court system dissect this issue and separate it. This person had spent way more than the PPD or the regular pension payments would have equated to. So it's very difficult for us to find that data. We are. Go ahead, Representative.
Oh, no, please finish your thought.
Sure. So we are, it's very frustrating and clear when we get a complaint. And I did have highlighted in my written testimony to the panel last year, a fire lieutenant from the city of Waterbury, who had suffered significant leg injury from the unfortunate action of a fire apparatus while he was responding to an emergency due to catastrophic brake failure. He had an opportunity that is becoming less and less in our career of having positions available that are not firefighter positions. In his case, he was able to go to a dispatch position or their communications division, which no longer exists because of private contracting of those types of jobs. So, he was able to complete his career, and thankfully he was able to retire. But the extent of the injury caused long-term surgeries, reparative surgeries, recuperation, rehabilitation that surpassed his period of retirement. And it is in his case where the PPD award was not able to be a determination by his treating physicians until after that retirement had taken place.
I see. No, listen, these are very important, insights into this discussion. I really do appreciate that. Obviously there is, as we kind of, think through this or analyze this, there is obviously the question of firefighters, police officers, law enforcement, and then there's a broader category of all municipal employees. And, one has to consider if these are different categories or perhaps they're the same category in the end. There's also the question, maybe you're saying that for firefighters, there may be already a practice. And if the practice is already kind of there, then it makes kind of the consideration both ways. If everybody's already doing the right thing, but we don't want to force it on maybe certain other set of municipal employees because so there's a lot of discussion to be had there as to what is the practice, where are we in the the real landscape, the real world out there. We live in the legislative world here, then there's a real world of practices in businesses and in municipalities which always is ahead of us. People already, we think that businesses are already taking care of things. Some of them they understand that if they do not behave well, they don't get any employees and they get out of business and so on and so forth. And then they're bad actors and all of that stuff. So we have to think about that. And I see your point. I might have some questions on data really as to what is the practice and is there a differentiation within municipalities and perhaps even within your municipality, whether the offset is applied to firefighters, but not to perhaps, their town employees. And so we'd kind of want to know about that. How are different municipalities really doing it? And maybe if there are others who come after you, I might, who may have expertise, I'd like to ask that question. But you've been very helpful in kind of opening that line of thinking as what's being done already. And is there a differentiation with different categories of municipal employees at this point in time? Thank you, sir. And you may comment if you'd like, and I'll pass it back to the chairwoman.
Thank you. I do think,
Chairwoman, I apologize for interrupting. May I just I have 2 points to respond to Representative Aurora's comments. First and foremost, the point of the practice of municipalities is a crux of the intention of the bill, and it actively, whether I say one municipality participates in this or 12 do, or a majority of them do, or a minority of them do, the point is that there's nothing that prevents them or precludes them from practicing it. So once we identify, the difference between that, the PPD is a benefit, not related or connected to wages or salaries, that really is the crux of this. It can expand, it can retract, it can be based on the economic flow of the nation and really not necessarily of Connecticut. So, the understanding is that we're attempting to preclude any of this practice to continue. And the second point that you had mentioned, I'm sorry. The second point that I wanted to mention is you were talking about other employee groups and or vocations within the municipalities, and of course I could say that I'm an expert in the field of the fire service because I am a firefighter in the city of Danbury. Also as a union official, one of my primary jobs within my local is to manage and assist members through the workers' compensation process. But the understanding is, and certainly not to minimize any other trade, but the organizations like NFPA set specific physical standards for firefighters to be competent at their positions, whereas a injury to a leg or an arm or a hand or burns to the body may not disrupt or diminish the aspect or workload of a teacher or some of these other vocations. So that's where I believe the fire service is seeing a greater impact of this, because it's unfortunate that during the course of their duties, they're becoming fully disabled from their positions, and they can no longer continue operating at their career.
Thank you, Jeff. And I think that was very helpful because you brought us back to the main point of this, which I think is critical, which is that this is an award. It's not wage replacement. It's a workers' compensation award for permanent partial disability. And so the issue that's before us is whether or not a municipality should have the right to offset a person's pension, a pension that they earned over years of service to the city. Do they have the right to offset that pension, reduce that pension essentially by the amount of the award? And I think that's, you said it's the crux of the matter. I really appreciate you bringing us back to that point. I do think it underscores also another question that may have been confusing a little bit in some of the previous testimony, but there was a suggestion that by doing this, that we would increase pension costs. And I wondered if you could address that. does this offset, or eliminating the offset, would that increase pension costs?
That's a excellent point and a great question. So when we look at the cost of pension, which has been a hot topic for the last decade, probably even more, but the misunderstanding is that this is coming from municipalities' direct funding, whether it be through the pension fund itself or as put earlier today, I believe, an unfunded mandate. And that is not the case at all. Workers' compensation, obviously required by state law for every employer within the state, but specifically for municipalities, they're required to have either an insurance carrier that protects from workers during their times of injury, or be self-insured for those purposes. So the funding for the PPD benefit would be incurred through that insurance policy, or through a budget item for the municipality's self-insured status. So very similar to an automobile accident. Obviously, they're going to make the replacements for the damage of the vehicle, but they're also the policy is also carried for the injuries of the people within the vehicle. So will you see an increase in insurance payments? Not specifically based on this particular issue. What you will see is just normal cost derivatives based on paying for the insurance, not direct cost increases. As an example, to a specific injury, significant back injury, a loss of a limb, and a flat dollar amount awarded through that schedule in the statute, and then not billed to the municipality for that specific cost. Does that answer your question, Senator?
Absolutely. That was really important testimony to also, to hear and to have as part of our public record. I thank you for your testimony today. I think that you and several of our speakers have really been able to clarify what sometimes is not a well understood issue. I know I've been here, it's my third session, hearing this issue, and I'm beginning to feel like I understand it well enough to really strongly support your efforts here. So I really appreciate you bringing it forward and the amount of time that we've had today to really pay attention to the specifics and the details, because I think you've helped clarify a lot for us today. So thank you for being here. I see no other hands at this time, and so I'm going to move to our next speaker. Our next speaker is Alex Brown from the ACLU Smart Justice Leader. Alex, I know I saw you earlier.
Hello, Hello.
Oh, yes, there you are.
Hello, Representative Porter, Senator Kushner, and Ranking Member Senator Sampson, Representative Aurora, and distinguished members of the Labor and Public Employees Committee. My name is Alex Brown, and I am a Smart Justice Leader with the ACLU of Connecticut. I am here today to testify in support of HB 5248, an act concerning collateral consequences of criminal convictions on occupational licensing. I am currently a student at Central Connecticut State University, working towards a degree in social work. I am also a person living with a record. I have experienced firsthand the enormous challenges and frustrations of trying to rebuild my life after I paid my debt to society from my conviction 10 years ago. Today, I am in college, majoring in social work because I want to address the mountain of problems around mass incarceration and because I passionately believe that all people deserve an equal opportunity. Unfortunately, due to my background, the barriers for myself and others who society is refusing to accept are suffocating, and I know that my next career steps of becoming a licensed clinical social worker will be especially complicated, if not impossible, due to my record. Employment barriers faced by people living with a criminal record have only gotten worse since the COVID-19 pandemic. Agencies working to help find people with records employment found that compared to 2019, only half as many people looking for jobs were able to find placements. People living with a record are less likely to have access to unemployment insurance, sick leave, health insurance, and rainy day savings. Experts estimated that once jobs start coming back, people with criminal records will likely be the last to see their unemployment rates lowered. It is also important to note that these harmful employment effects are not distributed equally across society. Racial disparities in Connecticut's criminal legal system are also replicated when people return home from incarceration. Because Black and Latino people are disproportionately incarcerated, they are likewise disproportionately rejected when they return home to the community and seek to build a life worth living. Poor chances of employment or stable housing have a devastating impact on Black and Brown people. Every person who is living with a record needs an opportunity to be able to support themselves and provide stability for their families. This is true for people who are just beginning their reentry process, as well as for people who have been back in their communities for decades. People like myself living with a record have a lot to contribute to Connecticut, and we should be eliminating barriers to employment and licensing so that people can become truly successful members of this state. I hope to graduate next year from CCSU and look forward to being able to apply my skills that will welcome my passion and expertise to help people. But I feel that I will not get that opportunity, or that Connecticut won't allow me to advance in my career solely due to my record. That is why I strongly urge the committee to pass HB 5248 and give us the chance to become successful members of Connecticut. Thank you for listening to my testimony.
Thank you. Thank you for sharing your story and for all that you are doing to make sure that you and people in your position get fair treatment. So we really do appreciate that. Looking to see if there are any hands. I see my co-chair, Representative Porter, has unmuted, so I'm guessing you want your hand raised.
Yes, thank you, Senator Kushner. And I really have no questions, Alex. You know, we've been working at this and chipping at the bit for quite some time to get this done. We understand the necessity of it all. I just want to thank you for continuing to fight the good fight and to bring lived experience voice to this issue. I think that is very important. And I do just really believe that if we can put our reentry population to work in sustainable, livable wage jobs when they're returning back to communities, that it not only benefits them and their families, it benefits the state as a whole and helps to drive our economy. And I think that is something that is very much needed right now. So thank you to you individually, but as well your team at ACLU for always being the voice that's needed to push the issues that aren't always comfortable. Thank you, Madam Chair.
Thank you. Thank you very much, Alex, for being here with us today.
Thank you.
Next
Madam
up,
Chair, Representative
I see,
Winkler has his hand up.
I now see Representative Winkler. Sometimes the hands like fade into the background of the ceiling in this case. So, but Representative Winkler, please do ask your question.
Yes. I have a friend who blames everything on the Puritans, no matter what's wrong with society. Do you have a better explanation for why we turn every criminal conviction into a life sentence?
I think I think the fear of our population really brings those steep sentences and the lack of education on just across the board of the population that we identify as. I don't have a better explanation though. No, I don't have a better one.
So people believe that somebody makes a mistake and that makes them a bad person forever?
I do believe that society as a whole rejects us once we've entered the system. Yes, I do believe that we are seen almost as second class now and no longer on the same playing field.
Thank you. Thank you, Madam Chair.
Thank you. And thank you for bringing out those points. So Representative Winkler, I think your question may have been a bit rhetorical in nature, but I applaud you, Alex, for being able to handle that. And it shows that your education and your commitment has paid off. And we do appreciate that there's something wrong with the system that creates a second-class citizenry because of a previous mistake. So thank you for being here and advocating.
Thank you.
Next up, we see we have number 33, Rory Whelan.
Good afternoon. Thank you, Madam Chair, honorable members of the committee. My name is Rory Whelan. I'm the Regional Vice President for the National Association of Mutual Insurance Companies. I will be submitting written testimony on a number of bills. I would like to briefly remark and offer the committee a suggestion on Raise Bill 5249, which is concerning non-compete agreements. As I read this agreement, someone mentioned earlier when Eric was speaking that Connecticut is the insurance capital of the world. As I read this agreement, insurers who have what they call captive agents, meaning the insurance agent just sells the product for that one insurance company, but they are a general contract, independent contractor, that would be void when this bill is enacted. So you would be prohibiting insurance companies from having captive agents. It would have a significant impact on many insurers in the state of Connecticut. It is an easy fix. You can simply amend the bill and say this does not apply to those licensed under, and forgive me, I don't know the statute, but the licensing statute for insurance agents, you could just refer to that, and this problem will go away. If you have any questions, but again, I understand where you're going with the legislation. I think it's laudable, but there is a unique to the insurance agency, and not every insurer, right? There are different business models, different. Some of them you could just go online. Some of them have independent agents that sell a number of different policies for a number of different companies. But some of the larger companies, in fact, have these agents who do benefit from their exclusivity in terms of marketing, advertising, back office tasks, and also like the fact that being a captive agent with you're more likely to have a solid source of income and clients.
I think this testimony was helpful to us today. I would encourage you to send us an email that describes this particular exclusion that you're looking for so that we can look into it further.
I will, Madam Chair. Thank you.
Thank you. And I see no other hands up now. Oh, I do see Representative Porter. Now I see your hand.
Thank you, Madam Chair. And I just want first, thank you for your testimony, Mr. Whelan. You refer to these insurance agents as captive agents. And I'm just trying to gain some clarity around the impact that the bill will have.
So it's an industry term as opposed to independent agent. So an independent agent could sell for a number of different insurers. A captive agent just sells those insurance products for one insurer.
So you're saying that the captive agent, you're agreeing that they should be under, is this, and I'm asking because I'm not sure if this is what you're saying.
No, what I'm saying is you would no longer you would void those agreements, and you would no longer allow captive agents in insurance.
Because they are signing non-compete agreements in order to be
Correct.
captive agent. Okay, thank you for that clarity.
But again, there are certain benefits, and people make choices if they want to be an independent agent or a captive agent.
All right, thank you. And we do look forward to the information that will be forthcoming. Thank you, Madam Chair.
Thank you. Thank you. And now we are up to the 34th speaker on our list. And I have to again recognize another one of my constituents. So this is great today. I'm getting to see folks from my part of the state. So please proceed, Chair Volpe.
Thank you. Well, it's also notable that I was just in New Haven dropping off some donations there in Representative Porter's district as well. So it's nice to have that connection to both of you today. So Senator Kushner, Representative Porter, Ranking Members Aurora and Sampson. My name is Tara Volpe. I'm speaking in regard to HB 5248, an act concerning collateral consequences of criminal convictions on occupational licensing. As a person who has an understanding of violence prevention, I'm aware that creating a pathway for people with criminal records is an important component in allowing individuals to successfully participate in family and community life. Allowing viable employment opportunities to people living with criminal records allows those individuals to earn a fair living where they can support themselves and their families. Therefore, I support the portion of the bill that makes changes to licensing eligibility criteria for people living with a criminal record. This change not only helps to end practices that contribute to families and individuals living in poverty, but helps to support the success of people who want a fair chance, want a secure work that will increase their family's income and quality of life, and want to live with dignity. Additionally, since we currently allow the state using its clear and fair individualized assessment standard for hiring folks with criminal records to determine if job positions are suitable for these individuals, allowing private business owners to make those same determinations for their own businesses makes sense. It's only fair and reasonable to allow and trust private business owners to make the same determinations that adhere to to what the state does for themselves to determine who they can hire. It is for these reasons that I ask you to support the portion of HB 5248 that makes changes to licensing practices, and I ask that changes be made to the bill that would allow business owners to make determinations about those they can hire using the same criteria the state uses. Thank you for letting me speak today.
Thank you, and thank you for your advocacy. We have heard now from a few of our members of the public that there's some suggested changes to this bill, and I assure you we're going to look at those closely and would again encourage you all to communicate in writing through email those desired changes so we can make sure that we don't that they don't fall through the cracks. But it's great to see you here, and I don't see any other hands at this. Oh, Representative Porter. You know, that is the best way to get my attention. I appreciate that.
I found that out in other committees as well. Just thank you, Tara. You have always been on the front lines for all good reasons. I mean, the way that you advocate is commendable. So I do want to thank you for always taking and making the time to be a voice for those who aren't necessarily able to be voices for themselves. And, you know, I coined it, you know, if it wasn't a life sentence going in, it shouldn't be a life sentence going out. And, you know, I say that and it resonates because of the conversations that I have with the many re-entering citizens we have coming back home from, you know, incarceration. And I think that, you know, your suggestion is well taken, as well as others that have been made. I agree with Senator Kushner. Please put it in writing.
Absolutely.
We are intently listening, but we've got other hearings to go. We've got a lot of things going on, different committees we sit on. It's an inundation of information. So if you can put that in writing, just as a reminder and a follow-up, that would be greatly appreciated.
I absolutely will. No problem.
All right. Thank you. Have a great day, Tara.
Take care. Bye.
Thank you, Madam Chair.
Of course. Next up, we have, all right, this person is not a constituent of mine. I just want to be clear, but you live very nearby. But next up is number 35, Stacy Zimmerman.
Hello, Madam Chairs and fellow members of the Labor and Public Employees Committee. I am not a constituent of Senator Kushner's, but am from Western Connecticut, so we're keeping on a trend here. I always start off by wanting to say good morning, but this has been a pretty boisterous hearing. So if you think after 20 years, I'd figure out that I'm never going to actually testify in the morning. I represent the Service Employees International Union. We have 65,000 members, both public and private, in the state of Connecticut. And I want to commend the committee for really tackling some great issues this year. We support this whole agenda. I mean, I think I've only said that twice in 20 years. And this is the second time in this committee. So once again, you guys are putting workers forward, workers' rights forward, and the concerns of the community forward in a way that we haven't seen in a very long time. And I want to commend you for that. I'm going to spend the bulk of my time talking about SB 209. It's the probate bill, and that concerning the status of the probate court system employees. We heard from the administrator this morning, and I sat and took some notes. And I have a little concern about how it was framed by the administrator. They're clearly employers. They are clearly employers. They set the benefit rates. They set the personnel policies. And judges may be supervisors, but they are not the direct employers. They're worried about having judges having appointments. They can have an aide. That's fine. They can have one person that's not part of the collective bargaining agreement, an employee at will per se. But these folks are the ones that make this system work, that were there, as you heard, during and throughout COVID. They were going into an office in many cases, depending on what judge you had, by the way. So there was no public health positions being followed. It was the will of the judge. And that just shouldn't be allowed in this day and age, especially during a pandemic. So, you know, they did bring up them. We did a 2011, we did some restructuring. 2009, we did some restructuring, and that's great. We tightened up the system. We brought it from the archaic patronage system it used to be into now a much more concise state-run patronage system. So I guess we're moving forward. But these are the only employees of this nature that don't have the right to collectively bargain. And you saw last year how we had them turn out, not in droves, but we had many turn out and speak. Why aren't they here? Because they're afraid. They're afraid because of the fist-pounding animosity to this bill that both some judges and the administrators have. They're afraid that if they speak out, that someday they will be retaliated against. And that's what this law can help prevent by giving them a voice at work. A voice at work is so meaningful when you watch other state employees receive raises and healthcare COLAs and all these things that they fought so hard for. And it took the probate workers 10 years to catch up. And that was because we put pressure on them through a unionization effort. This is disturbing, it's sad, and it's time to do away with this patronage that we've seen and move forward to what really would be a transformative probate system where the workers, the public, and everyone can feel their voices heard. And I'm happy to answer any questions. And most of the concerns, just to follow it up, that I've heard from the administrators can be addressed in bargaining. I mean, that just because you have a union doesn't mean the contract's written. So I guess that's how I'll close.
Thank you. Thank you for your testimony. There was a question that was raised previously in previous testimony about the possibility that this would create, you know, many separate bargaining units with disparate treatment. And I wondered, I had responded that I, you know, assume that's something that we could address. Is that one of the issues that you think could be addressed?
I think that this law would make the association the employer of record, and we'd bargain one contract for everyone, and there'd be different positions involved in that. But this is not about setting up 60 different bargaining areas that the state would have to deal with. It's setting up one that are administered in 60 locations. I mean, we do that with every other organization. Why can't we do that now?
Thank you for that clarification. I think that was important and something that we can certainly look at whether or not that particular clarification would address at least one area of concern and hopefully allow us to move this process forward. And, you know, I also appreciate your underscoring the concern that we would have as a legislature that some people who testified in the past were concerned about retaliation for supporting a bill like this, because under federal law and under state labor law, workers who have the right to organize, there's no, it is a prohibited practice to retaliate for speaking out in favor of unionization. And so that does underscore the importance of making sure that these workers have that, as a minimum, have that right as well. So thank you for bringing that up.
I've even been told that some judges are concerned to show their support because of how other judges would take it. So this isn't just the workers. If judges are afraid, there's a real problem going on.
Thank you. Thank you for that. Okay. I knew you were going to, you unmuted. Representative Porter.
Thank you, Madam Chair. I just wanted to say thank you, Stacey. It's always good to see you. And it is awesome that you have been able to be a voice for workers who are, you know, working in fear and living in fear. and feel that they're unable to come before us to speak on their own behalf. I think that's very unfortunate. And what you just mentioned, the fact that you actually have judges who are seated having that same fear speaks volumes. And it also says to me that this is very much needed, that this is an issue that needs to be addressed head on and immediately. I see this as a sense of urgency. So I'm truly hoping that this is the year that we get this done and that we'll dispel the myths and the concerns that are being expressed. So thank you again for your advocacy, and thank you, Madam Chair.
Thank you. You can't professionalize this operation without prioritizing the workers. It just can't be done.
Thank you. Thank you for your comments here today. And now we will move to our next speaker, and that is number 36, Amber Blanges. And now we're back on track. It's another constituent of mine from the great town of Sherman. Good to see you here today.
Thank you, Senator. Senator Kushner, Representative Porter, Senator Sampson, Representative Aurora, and esteemed members of the Labor and Public Employees Committee. I'm happy to be back with you. My name is Amber Valangas, and as Senator Kushner said, I am a resident of Sherman, Connecticut, and I'm a volunteer with the Restorative Action Alliance. I'm here today to express my support for the concept of House Bill 5248, an act concerning collateral consequences of criminal convictions on occupational licenses, while urging the committee to make some critical revisions. So while this proposal that has been in the works for a long time is a positive step forward, it just doesn't go far enough to address the hundreds of barriers that people living with records face while seeking employment in our state. So to contextualize my remarks, I will share that I'm a member of a system-impacted family. I'm a crime survivor, and I'm also a person who served on the employment subcommittee of the council on the collateral consequences of a criminal record that gave rise to this bill. So I have submitted written testimony. I don't want to use my time for that. I would like to share a couple of stories. Just yesterday, I was speaking with a woman who is the spouse of someone who is impacted by the criminal legal system. And her whole family is affected by this discrimination by an employer. And not only was it just a situation where her spouse could not get a job, it was that he had a job. And then when he was up for a promotion, a background check was done, and he was actually dismissed after having worked there for 5 years. So these are all the things that are happening. People are discriminated against. They are exploited in jobs. I have spoken with people who are working very hard labor, and people are not following labor laws because they're like, where are you going to go because of your record? So we need to be taking all of those things into account when we're talking about these issues. The other thing that's really important to think about when we're talking about these issues is this is not an us and them scenario. Again, as I mentioned, this ripples out to entire families in our communities. And since we're talking about in our state, 110,000 jobs going unfilled and 80% of employers not being able to find people to fill positions, it is simply crazy and counterproductive to economic development to be placing barriers in front of people. So what we really need to do is we need to break down the barriers. For a lot of people, this is life and death. They're falling into desperation. They're falling into suicidal ideation. They can't support their families. And so as much as we want to take measured incremental approach, the urgency is now. The urgency is people need jobs today. They need to support their families today. And our state needs economic development today, not in the next session when it's more convenient. So I would really urge the committee to really look at the revisions that are in my written testimony that have to do with removing those blanket revisions, providing some support for employers who do fair chance hiring with safe harbor laws, because a lot of employers want to give people a second chance, but they're afraid of what that will do to their business because of perceived risk. So I would really encourage this committee to continue to work on this issue, but to get done what we can get done in this session. And I'm happy to take any questions from anyone on the committee.
Thank you, Amber. And I don't see any hands, but I will, Representative Porter.
I always figure you know this, but the unmute is a hint. That'll be our code from now on. We unmute, we want to speak. Amber, always good to see you. And you know that Senator Kushner and I definitely know the stories behind your testimony and our full support of that. We will definitely take a look at your suggestions as well as everyone else's. It is a heavy lift. This is not a popular conversation or a comfortable conversation to be having. And we really are looking to gain and garner as much support as we can. So thank you for coming on today to help us expand the knowledge and education around this and why it is so critically important and why it is a sense of urgency, that needs to be adapted when we talk about these issues and not just this one. It was said earlier, we have been quite enthusiastic with our agenda for this year, and it's because it is much needed. And we're responding to that need as best we can. So thank you again. And hopefully we'll get done what needs to be done. But if not, know we are consistently and persistently working on it. Thank you, Madam Chair.
Thank you. And Amber, before you go, I do want to just take a point of personal privilege to acknowledge also the work that you have done on behalf of aplastic anemia awareness. I see you're wearing red today, as am I. We have a member of our community who lost her grandchild to this horrible disease. And your work with the Julius Wings Foundation has been much appreciated in our community. So thank you for that as well today.
Thank you for acknowledging that. And Representative Porter, I want to thank you for the work. I know that the committee is doing the work. I know that the issues are being discussed. I know that they are complicated, but we're just going to keep pushing.
Thank you. And give my love to Doris Clark as well.
Yes, counting on you to keep pushing, Amber.
Thank you. So our final speaker for today is a friend, and we're happy to recognize the last speaker on the list, Ed Hawthorne, who is the president of the Connecticut AFL-CIO. And Ed, I know you've been before us before testifying, but never, I don't believe you've been here as president of the AFL-CIO before. So we welcome you in your new capacity and congratulate you on the new position.
Well, thank you. I know I'm last today, and I promise I won't be any more than an hour. Okay. Thank you for the introduction. This is my first time testifying in this capacity for the AFL-CIO. Previously, it was the Western Connecticut Area Labor Federation, but now I am proud to represent over 200,000 working men and women in Connecticut as the president of the Connecticut AFL-CIO. I'm here today to stand in strong support of several bills: Senate Bill 222, House Bill 5249, House Bill 5246, and Senate Bill 209. We'll start with the top of SB 222. It would require the employer to notify a person seeking workers' compensation if they would discontinue prescription drug coverage and alert the worker of his or her right to request a hearing. It also prevent any employer or insurance company from discontinuing or reducing prescription drug coverage unless the workers' compensation commissioner approved this in writing. We urge you to restore the integrity of the workers' compensation grand bargain of the employer and employee by supporting this bill. It's troubling that this isn't already the case, truthfully. HB 5249 concerning non-compete agreements. It's common sense. Non-compete agreements are for trade secrets, reducing costs associated with turnover, things like that. So the bill, I believe, is narrow enough to catch the people that non-compete agreements really aren't for. So what we're asking, and it's becoming more and more prevalent. And in my previous job, I used to see this a lot. I worked in unemployment compensation before, and I would see this with hairdressers and things like that. Somebody that, a non-compete agreement wouldn't, there's no trade secrets for hairdressing, things like that. So by eliminating a worker's right to move from position to position, really the purpose of it is to artificially suppress wages, reduce overall economic growth, and just basically decimate the ecosystem that is our free market economy. I would urge you to, support this bill to prohibit such agreements. The recall rights, HB 5246, an act extending recall rights for certain laid off employees. No one saw the variance last year when this was enacted, and we're merely asking that you help support the mostly Black and brown men and women who were deemed essential during the pandemic, through no fault of their own, got laid off. We're asking them to come back to work. And as far as whether or not it's overly burdensome for the employer, getting a hold of the people, they'll make that up tenfold in having to retrain people. If you look at Milagros, for example, she was at McDonald's for 15 years. She could probably do the training of the people that they would have to bring in that are new. So, when you say, it's hard to get a hold of these people, there's certain things that you have to do, yes. But on the back end of it, you're saving time and you're saving money, and it's good for business. And lastly, the probate workers, let's call them what they are. I mean, you have my written testimony on it, but they're state employees. That's what they are. If the judicial system has employees and they're considered state employees, why isn't probate? Once again, it's something that should have been taken care of years ago. And, let's call them what they are, and let's allow them the right to organize. And to Sister Stacy's point, just because you have a concern doesn't mean it can't be bargained for. So we're asking for the right to sit down and talk. That's really all we're asking for. So thank you for the opportunity. I'm trying to be as brief as I can, knowing that I am last, and I'd be happy to answer any questions that there may be.
Thank you. I do see a hand, Representative Aurora.
Well, thank you, Madam Chair. Thank you, Mr. Hawthorne. I really appreciate you testifying, and congratulations on your new role. Read about in the press and a few months ago, and we really appreciate you giving your time today. Our questions, and I hear what you're saying, all of it. There is, from a probate court perspective, there is they have their own structure which has been working well, right? And there will be positives and negatives for the employees, and for the and quite a disruption in certain ways, lack of autonomy, and I understand from where you sit. I understand why you say why you advocate for what you're advocating, but can you see the other point of view? Because we got to work together, right? We all have to work together, give and take, compromise, and you lead a, just as you said, a movement which represents 200,000 workers. We work for a committee which represents 1.75 million workers. So I really want you to see from the other perspective as well. That the probate court administrator, who are doing a fantastic job over 10 years, are saying, well, listen, this is going to create other problems. This is going to have this issue, and so on and so forth. And the current system really works quite well. And if there are certain issues, we can definitely reach out to them. Is there a compromise? Do you see the other side as well? We see your side. We understand that. But, do you see the other side as to why they're saying and why we have a sympathetic view to what they're saying?
Sir, unfortunately, I do not. When I first got out of school in 2009 now, wow, that was a while ago, I worked as a clerk for the Superior Court, and I was a state employee. I failed to see the difference of a probate court judge and a Superior Court judge having a state employee and not a state employee. That system works very well as well. And those are, people that have a collective bargaining agreement, that have worker protection. Collective bargaining agreements, don't see it as a negative. It's a positive. Down, you talk through issues, and a lot of the things you actually out of. So problems that are brewing, if you have a voice in the workplace, you can come to your supervisor and not have the fear of getting fired. Because a lot of people now, as Sister Stacy said before, people are afraid to come forward today because of retaliation. If they had the protection of a collective bargaining agreement and have that fear, the problems that may be brewing under the surface would come to light and be solved. So, don't think of it as a conversational thing. It's merely giving people a voice in the workplace they wouldn't have already had to make the workplace better in the end. And that's really good for everyone.
Right. Just so you said that thank you very much for that input. The Superior Court system works very well, and we're very excited about that. And the other system works well too. Right. And that's my point of view, that, that system works well too, which obviously you clerk for one, you didn't go for the other. They were able to act very nimbly and make some changes. It's a smaller system, and they were able to make some nimble changes during the pandemic to help their employees, which from the state perspective, they couldn't. They had different, format because they had to be open in person. So, those are the points of views. They're different points of views. It's not a confrontation at all. It's about pluralism, that there are some places where, you may have a union reps which are doing a fantastic job or a good job. And another place, maybe it's okay if it's not working. It's not, conquer the world kind of a thing. As I said, there's 1.7 million people in this working in the state. Just like in other businesses, there are businesses with different formats, right? Some businesses are, like, as I would say, Superior Court. Some are probate. And that could be in finance, and it could be in manufacturing, and in this and in that, and so on and so forth. So, my point of view is just, I was hoping to see if you could see that there are differences, and we can live with the differences, and perhaps there is always a medium way, not my way or the highway kind of approach.
Unfortunately, Representative Aurora, there are places that I'm sure we disagree on. But this is not one of them. I look at a Superior Court judge as having state employees and a probate court judge as not. And I ask myself why, and I can't logical answer of why. Treat them as what they are, and that is just like state employees.
Sure. By your point of view, there's some nonprofits, there's different form of organization in the similar kind of line of work. But that's just my viewpoint. I don't think we are here to debate. We're here to take your opinion, so that helps us understand. And finally, on your support or your testimony for the other one, for the recall rights, for the recall program. There's a discussion earlier that there is a certain element which we heard of abusive employers, of employers who take advantage of others. And, you and I and all of us would agree that, we have to take action there and make sure that those are remedied. And you've worked at you've been at the DOL, and you've seen plenty of situations, and you must be you're an expert at that. My point of view is, but here we are talking about a tight market, which is changing in many ways because of the way, COVID has changed the world around. We need to make sure that we give people kind of this flexibility, businesses this flexibility to, sometimes they may retain more of one kind of employees, and it may not be in order of seniority. How do you see that as a challenging situation, that everybody has to go to that order of seniority, rather than, give the businesses their discretion, and give them a benefit of doubt that many of them have really hardly, but were nearly went bankrupt in many areas of work, and there were many heroic stories where the employers or the entrepreneur really put on everything they had online to retain their base number of people and the business and the lease, so as to say, and they have emerged in some sense okay. But I think this might be a good time to basically give them a little flexibility. That's what I hear on the other side. So do you see that point of view, or is that also nothing which you see any good in that?
Representative Aurora, unfortunately, the flexibility that you talk about often ends up, hurting those that are most vulnerable. Our older workforce, a lot of them left the workplace because they were scared, and rightfully so, of this deadly virus that came out. So when they're calling these workers back to work, some of the, maybe not the employers that you're referring to, but some of the other employers may actually call back people that are younger and will accept less pay. And that's just not right, because these people, did something for their health and through no fault of their own were laid off. And if that employer wants to take advantage of folks and not recall the people that can do the job, have proven they can do the job, and were laid off for no reason other than a deadly pandemic that ravaged our economy and our state, that's just not fair. So I think it's very reasonable to extend it one more year. And I think in the end, it actually does help employers. Like I said, retraining takes a lot. And a lot of these people that they're calling back, they're already trained. That's saving the business money. So in my opinion, you're actually doing them a favor by saving them from themselves.
Oh, by saving them from themselves, because what I hear is that some of the needs have changed. And that's one of the things, we want to be careful as to say, well, everybody is bad and they don't know how to manage a business, and we will save you from yourself, whether it be, a parent, they're telling that to a parent, you don't know what you're going to do with your kid. And we're going to, in some context, and in the other context, to the employer or the business creator who's managing, who's got created 40 jobs. And you're going to say, well, I'm going to, you don't know what you're doing. I'm going to tell. I think that's a little dangerous, don't you?
Sir, I believe that they should be looking to hire back the people that have proven they can do the job. And that is all the bill is asking them to do. And extending it for another year is reasonable, considering the multiple variants that have hit since the bill was passed.
Thank you, sir. I always appreciate your input here. We hope to see you more in the future. And we will see you more in the future, and that's just a matter of fact out there. And the way this committee is constructed is really, that's one of the concerns we always have with some more union committee, labor committee. But I thank you for all your input, and look forward to working and finding compromise in many ways possible. Thank you, and back to you, Madam Chair.
Absolutely, Representative Aurora, and always thank you for your passion and thank you for your questions. I truly appreciate it. I really do.
I do want to make a point that this committee is called the Labor and Public Employees Committee, and I think we all recognize that we serve all working people in Connecticut, all these working families. And while there are a number of union representatives that speak here on behalf of working families, their own members, what I applaud so much in the labor movement is the many, many bills and the many, many times you support legislation that wouldn't particularly benefit your own members. They may already have those benefits, but actually support initiatives that would help working people who don't have a union and don't have that protection. So I don't think this is a union committee. This is a committee that really advocates and is charged with the responsibility of making sure that we're addressing the needs of working people and working families here in Connecticut. So thank you for your testimony. I do see a hand, my dear friend and co-chair, Representative Porter.
Thank you, Senator Kushner. And as always, you have said much of what I was going to say in response to what we just heard. And I do thank you, Mr. Hawthorne, President Hawthorne.
Oh, no.
In your capacity, well, here today, we are going to address you as President Hawthorne. Well-deserved. Congratulations. I just want to thank you, a heartfelt thank you, for always being an unwavering voice in support of what's right. It's not my way or the highway. It's what's right. It's what's right. And there's no compromise in doing what's right. What's right is right. And I think we've heard enough from workers as well as some employers. And let's be mindful of that. It's not just the workers. We have heard from employers as well. So there is support on both sides of this issue from both sides, employers and workers. And I think that, the mention of unions, the only thing I'll say about that is there was a time when unions were really, really strong. And that time was reflected when we saw the most increase and expansive increase in the middle class. You know, they made sure that people had livable, sustainable wages, that they had benefits and health care and pensions, a retirement package. And it's these things that are really missing from the workforce. It is not a labor shortage. It is not a worker shortage. Workers are saying, this is what we need. And it is wages, it is healthcare, it is childcare. It is all of those things. So I thank you, you know, and the brothers and sisters that go out every day and fight on behalf of these workers. And it's beneficial for all involved. This is not a one-sided equation. This is not a one-sided benefit. This benefits us all, no matter where you sit. And I hope that we have the opportunity to get this passed so that we can dispel the myths and the concerns, because we know there's always been pushback. But when we've been able to get these things done, we've also been able to show that those concerns were really not weighted in the way that they felt they were. So thank you again. I wish you much continued success, and I look forward to seeing you back here to testify on upcoming bills. Thank you, Madam Chair.
Thank you, Representative Porter, Madam Chair. And I do want to say we had one person who was trying to get in to testify still. Thank you, President Hawthorne. I think we're done with you for now, but we did have one other person that was trying to get in to testify. His name is Rick Porter, and I know he was calling in.
Yeah, he didn't call back. I'm sorry.
He didn't call back. So Rick, we apologize that you didn't have the opportunity. It is sometimes technologically a little tricky when someone calls in from a phone, and it may be that you needed a new link sent. So we apologize. Would encourage you to file written testimony, and you can certainly reach out to our clerk or myself or Representative Porter, and we'll make sure that your testimony, what you wanted to say, will get disseminated to the whole committee. So after a not too long day, I mean, it's not too late in the afternoon. Many of our hearings go much later in the day. I do want to thank everybody for participating. And I want to especially underscore the comments that have been made about how there are good employers. And, you know, I'm the daughter of a small business person. I am the granddaughter of two, both sides of my family, small business people. And many of my aunts and uncles were worked in, owned small businesses. And so this has been my life. And what I know is that the people who own small businesses work incredibly hard to make a living and to also provide in their communities. And I would say the majority do the right thing. When a worker gets sick, they hire them back. When a worker has a need, they are there for them in many cases. And so what we're here to do is to make sure that we pass laws that won't negatively impact the good employers who are already doing these things, but actually will make sure that everyone provides a good workplace for their workers. So as a daughter of, I've been recognizing my family all week, having recognized my heritage, my Ukrainian heritage yesterday in the chamber. I feel privileged to be in a position where we can embrace our communities and all of the people who serve. So thank you all for being here today. It's been a good public hearing. We have two more coming up. The next public hearing will be on March 8th. And so we look forward to seeing you then. Take care, everyone.